only because I have, hopefully, yep. Okay, we are now recording, Mr. Chair, and members of the commission and everybody else involved out there. So this meeting is now being video. There's a video recording taking place of this meeting. The commission will start here in short order once the chairman makes the call to proceed. But I just wanted to make sure everyone out there is aware. Some of you are muted. We'll call in people as we start to hear particular matters. But Mr. Chair, we are now presumably ready to proceed.
Thank you, Mr. Richter. I'd like to call the Ohio Elections Commission meeting of April 8th, 2021 to order. Would you please conduct a roll call, Mr. Richter?
We'll certainly do so. Ms. Cunningham?
Here.
Ms. Tavares?
Here.
Ms. Kaufman?
Here.
Mr. Beatty?
Here.
Mr. Bromer?
Here.
Mr. Norman?
I am here.
Chair Kreitz?
Here.
All members are present, Mr. Chair.
Thank you very much, Mr. Richter. The first item on the agenda this morning is the approval of the regular meeting minutes of March 25th, 2021. All of the board members should have received those minutes. Any additions or corrections to them? If not, I'll entertain a motion that we approve them.
So moved, Tavares.
Second, Norman.
All in favor, signify by saying aye or raising your right hand.
Aye.
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 Opposed, same sign. Motion carries. The minutes have been approved. Moving on to preliminary reviews. The first case this morning is case 2020D-011, Watts versus Lenahan. Phil?
Yes. Mr. Chair, members of the commission, this is a complaint alleging. Not sure where that's coming from, but somebody's making a little bit of noise there. This is a complaint where the complainant asserts that the respondent did not.
Oh, hello.
Phil, you're muted. We can't hear you.
Phil.
I didn't think that I had remuted myself. Sorry about that. Mr. Chair, members of the commission, this is a case where the complainant asserts that the respondent did not include a proper disclaimer on various campaign materials. The complaint response and other materials have been provided to you in advance. You see my synopsis of the response submitted by the respondent and her counsel. The respondent submits a rather lengthy response, denies the allegation, asserts the respondent is not a candidate for the purposes of this statute as a purpose running for the office of the State or County Central Party Committee. I believe that both counsel for the complainant and counsel for the respondent are present if the commission would like to hear from them.
Yes, Mr. Roberts, on behalf of the complainant, is there anything that you would like to say at this time? Or do you intend to go ahead and call a witness? If so, we'll have to go ahead and have that witness sworn.
Well, generally speaking, I will interject, Mr. Chair. Generally, at the preliminary review stage, we don't necessarily hear witness testimony.
All right, sir.
But I will spotlight
Mr. Roberts.
Mr. Roberts.
Mr. Roberts.
Please proceed.
Can you hear me?
Yes.
Okay, thank you. I would only simply say that to reply to the respondent's response, I feel that it's non-responsive to the complaint other than the statute that Watts and Lenahan, neither one of them are candidates. I think that that's an important issue that the commission should look at because either they consider them a candidate, which Ms. Lenahan, by her own materials, she states that she's a candidate, and the effect, if the commission was to find that she is not a candidate, what the effect is throughout the state for all central committee, both county and state level, how this would proceed in all elections here on out, that more of a Wild West sort of no rules apply if they were to be considered that the Ohio Elections Commission has no way of reining these candidates in, or these, if they're not candidates, what are they? Simply because they don't fit the statute. Other than that, the respondent's response does not really respond to the complaint itself. I would say that we speak on our complaint itself. We've attached the documents that support our complaint. Other than that, I would simply state that I do have the complainant, Eileen Watts, here. I understand that you do not intend on us calling witnesses or having them speak, but she is more than willing to speak on behalf of her complaint in an attempt to support the necessity of the commission going forward and trying to do what this commission is meant to do, and that is to give confidence for the voters of the state of Ohio in election integrity. So other than that, I would say we would rely on our complaint. Thank you.
Well, thank you, Mr. Roberts. Are there any questions of Mr. Roberts by members of the commission? All right, then Ms. Guzzo, on behalf of the respondent.
Yes, thank you.
Good morning.
Good morning. Okay, may it please the commission, I'm attorney Peggy Guzzo with bar number 0089217 on behalf of Ms. Linehan, Melanie Linehan, for this hearing regarding Ms. Watts's complaint for violation of RC 3517.20. Prior to beginning with any opening statements, for the record, I would like to enter the following objections. On the jurisdictional grounds, 3517.20 does not apply to county and state central committee member candidates. Number two, in 1995, the statute was renumbered from RC 3599.09, which the United States Supreme Court ruled RC 3599.09, requiring campaign literature to have a disclaimer of who paid for it, violated the First Amendment of the freedom of speech. So our position on 3517.20 is that it's unconstitutional, or as it is being applied is unconstitutional. Alternatively, that RC 3517.20 is unconstitutionally vague as it relates to county and state central committee member candidates. And before I move on, my client is here at my office. Are you receiving some feedback from her in another room?
No.
Okay, good. All right. Without waiving those objections, in addition to the response, Ms. Linehan denies the allegations as asserted, as she believed that the statute did not apply to her. So there was no intent on her part to violate any statute, as she did not believe it applied to her. And then going forward, just breaking it down a little bit further for the commission, pursuant to 3517.01C3, as it relates to the statutes of reporting requirements for candidates of 3517.08 through 3517.14, candidates is defined, and I can read it for you. Candidates, notwithstanding regardless of the definitions of 3501.01, it says, of the revised code, as used in this section, as well as 3517.08 to 3517.14 and 3517.99 and 3517.992, candidate is defined under C3, has the meaning of 3501.01, but then it goes at the bottom and it says candidates does not include candidates for election of the offices or member of county or state central committee, president elector, or delegates to a national convention or conference of a political party. This is important because, as it states, candidate refers as defined not to include Melanie's race, which was she was running for state central committee as a member. It excludes that from the definition of candidate for those purposes of the statutes I just mentioned. And in particular, 3517.01 or 0.08 to 3517.214 relates to reporting. And what you'll find is that the statute of 3517.20, there's provisions in there that talks about people who spend more than what a designated amount is, which doesn't apply to her race, or reporting and violations. Also, but more importantly, referring to 3517.99, that's the penalty provision when you violate any of these requirements. And it specifically states that candidates are excluded from that. So in our argument that it's vague, even if you were to say that she violated it, your hands are tied, because you can't fine her because she's specifically excluded from the penalties. And you can't refer it to prosecution, which is your third option under 3517.155, is you have three options. One is to find there's no violation. Two, give her a fine pursuant to that statute, because it says 3517.993, which 993 says pursuant to 3517.992, which again specifically excludes state or county and state committee members from that. And then the third option is for prosecution for violating it, even though you can't give her a penalty. But there too, it specifically states that in 3517.155A2, when it refers to the appropriate prosecutor, it means in a case of a failure to comply with a violation of law involving a campaign committee or committee's candidate, a political party, a legislative campaign fund, a political action committee, or a political contributing entity that is required to file a statement of contributions. Again, she's not required, because candidates are specifically excluded from 3517.0 through 3517.14, which is the requirements for reporting. So that doesn't apply. And then B, in the case of failure to comply in violations involving other campaign committees. And that's not what the complaint is about. It's not other campaign committees. It's about her campaign. So based on those things, or based on those arguments, it doesn't apply to county and state central committee members. Ms. Watts herself must have been under that initial belief, because her literature also did not contain. She did subsequently, some pieces did have a disclaimer, but there were several pieces that she circulated that did not have the disclaimer. Just a second here. The only thing I would add, and I'm looking for, and I know Phil has it, but also I had mentioned if it goes, there's these statutes kind of intertwine, as I'm sure this commission knows. You know better than I or any of us out here, because you deal with this each and every day, and we thank you for your service. But I mentioned a designated amount, and that definition is defined as well in 3517.0. And it does not cover her race as well. It refers to legislative, local, and state, but it does not include her race for state or county central committee. And that is it. And I'm open to taking any questions if the commission should have any questions.
Thank you, Ms. Guzzo. Questions from the commission? All right. Mr. Roberts, do you have anything in response to what Ms. Guzzo has said? Mr. Roberts?
Yes, can you hear me?
Yeah,
Now we can.
Sorry about that. I think I was muted.
sure.
My only response would be as to the portion of her argument as to the part that she addresses wrongdoing alleged of Eileen Watts. There is no complaint against Eileen Watts at this point in time, so I would say that would be non-responsive to the complaint. At this point in time, there's a complaint against Melanie Linehan that is a repeat offense from 2014 against Melanie Linehan. So this is simply behavior that has been brought to this commission again against the same person. That needs to be addressed. The fact that she's trying to argue the non-existence of her candidacy, of being considered a candidate, I think it's a clever loophole argument, I think. But I think the effect would be wide-reaching. It would be reversing any type of actions that this commission might have taken against any other candidates that have run for central committee on the state or county level. So I think that would be a consideration that this commission would have to take into consideration, along with what the future ramifications for any candidates that run on this level that would going forward. So, with that being said, I don't think there's much more response other than, again, the pleadings speak for themselves. The exhibits that were attached on the complaint clearly show Ms. Linehan names herself as a, quote, candidate. So to identify yourself as a candidate and then come back in her response that says, I'm not a candidate, is a little bit disingenuous. Other than that, I would thank the commission for their service and await their position on this. Thank you.
Thank you, Mr. Roberts. Mr. Richter? Oh, I'm sorry. Go ahead, commission members.
Mr. Roberts, doesn't the language in 35-1701 specifically address that somebody running for central committee is not a candidate?
I think it does. It does state that. I did look at the statute. However, it does give a commission the ability to have some latitude on any person that is running for an election. This commission has the ability and has discretion on how they treat candidates. Are they only bound by the statute? I don't think so. I think that a commission has a certain amount of power and authority to deal with and discretion on how they treat candidates. The statutory discretion or statutory definition of candidate is not the only way of looking at whether or not an election is run fairly. If a person is following the rules of what this commission finds is the proper behavior of candidates. Now, if this person is running as a candidate for a particular race and it is on our ballots, statewide, countywide, locally, this commission, it falls under this commission. Is this commission looked at this historically as a race? Is it looked at as an election? And have they treated these type of candidates as candidates? I think that's what we have to look at. Now, again, I concede the argument that this is a clever argument as a loophole, but if that's the case, then I would invite this commission to say, yes, she gets out of this for that reason. But go back to 2014 when she was reprimanded for the same type of behavior and see, is this what we want? Is this what Ohio wants in a year when election integrity is looked at more and scrutinized more than ever before? Thank you.
I'm part of a state agency and I look at it and I go, I see a revised code statute which says to me, candidate does not include candidates for election to the offices of a member of a county or state central committee. I don't know how your argument is clever. It seems to me the statute clearly says that that person is not a candidate. I mean, the statute's clear.
I think the statute would be clear as to the definition for the Ohio Revised Code, but I would have to say, does the power and authority of the Ohio Elections Commission reach persons running for county and state central committee? I think that's the question that is posed to this commission.
I'm going to interject just to say this commission's duty and responsibility, as I understand it as the executive director, is to apply the laws of the state of Ohio that are within its jurisdiction. That jurisdiction extends from 351708 to 351722 technically, although 21 and 22 are no longer valid, and additional sections in 359903. In order to apply those provisions, the commission has to be aware of all of the various definitions that are provided for it that identify who is responsible for their activities and actions as they go about conducting their activities. 351701B3 identifies a candidate, and it explains all. It even explains that when two persons jointly seeking the office of governor and lieutenant governor are a candidate. But then there is the exclusion. Candidate does not include candidates for election to the office of member of a county or state central committee, presidential elector, and delegate to a national convention or conference of a political party. There can be those types of elections. Generally speaking, in Ohio, you don't see presidential electors appear on the ballot, although technically that's who you're voting for. And you generally don't see delegates to a national convention. While I can't say I speak for the General Assembly, the General Assembly enacted these statutes and applied these definitions and did so in an effort to exclude essentially candidates for state central committee from either including disclaimers, as we see here, or filing campaign finance reports. Now, is there an argument that says, yeah, that would be nice to see them file campaign finance reports if they do have financial campaign activity and put disclaimers in their literature? I think there's an argument for that. But right now, the statutes are very clear in stating that a candidate is not someone who is running for state, county, or central executive committee, state, county, or central committee or executive committee. And so therefore, I don't believe that it's applicable in this situation, and we should find no violation.
Any other questions or comments by members of the commission?
I have a question for Mr. Richter. I know as a part of this, they were asking that it be declared frivolous and impose a sanction and attorney's fees. To me, the statute's pretty clear that what they're attempting to do, or at least the complaint being brought, is not valid. I mean, the statute is so clear. Do you have an opinion in this regard?
That is certainly something that the commission has done, but only rarely in the past. I tend to withhold a recommendation on that in favor of doing so unless I see it as the most egregious cases, leaving it to the commission to make that kind of a determination. Certainly, the statutes are quite clear, and if the commission believes that it's appropriate to do so in this particular case, I can't sit here and say that the commission would be wrong in taking that action, finding this matter frivolous, and moving forward. Alternatively, you've heard Mr. Roberts make the comments that he has. Take that into consideration as well, and make your determination. Like I said, unless it's the most egregious case, I can't say that I see this here myself. But certainly, Mr. Norman and other members of the commission, if you decide that that's something you believe is appropriate, I wouldn't discourage you from doing that.
Mr. Richter, I have a question about that. Isn't it true that the statute under which we operate requires that the board first or the commission first decide that the allegations have not been proven before we can move on to the issue of whether or not reasonable attorney's fees are to be considered?
That is the way the statute reads. I believe it's 3517-155H that lays out the parameters for doing so. But it does allow for the commission to make that kind of a finding and apply the appropriate sanction.
But as a matter of procedure, the commission would first have to go ahead and decide that there was no basis for the allegations, correct? Or that
Correct.
They had not been proven.
That's
Okay.
correct.
Any other questions? Go
I have
ahead.
a question.
Go ahead, Sharon.
This is Commissioner Cunningham. And I have a question about, I know the executive director's recommendation is a finding of no violation, but I have the fundamental question of whether or not we have even jurisdiction of the case if they don't meet the definition of a candidate. I'm not sure that we ever get to a merits finding in the case, or we'd get to a frivolous finding, which might be a separate cause of action somewhere else. But I raised that issue for my fellow commissioners and the executive director.
I certainly hear and respect your approach. When a complaint comes in, if it meets certain requirements, I place it before the commission.
Of course, we have to determine our own jurisdiction. My question is,
right,
do we even have jurisdiction if the person doesn't meet the definition of a candidate under the statute and we have strict statutory limitations on our authority?
I guess the question is, does 351701 come within our purview as it relates to these central committee candidates?
Right.
It's not within our jurisdiction, but it obviously controls what we do. The commission's specific jurisdiction starts at 351708 and proceeds from there. But 351701 controls what the commission does. And so if someone wants to assert that someone is a candidate, then I'll take a complaint and move it forward, and place it before the commission for its determination on how it should proceed. My recommendation of no violation is that, based on as I look at, certainly we could also do a strict dismissal on these matters, but the assertion was that this person was a candidate. We found that presumably, at least I find, this person is not a candidate, therefore not subject, and therefore not in violation of the statute.
Well, if it's determined, Mr. Richter, that we have no jurisdiction to hear. If it's determined that we don't have jurisdiction, and we would agree with that, then we would not have any authority to go ahead and decide the motion for sanctions. Is that correct?
It never had that approach under this set of circumstances, but I think I think you are correct. Yes.
If we don't have jurisdiction, we don't have the ability to decide as it relates to the violation or non-violation before we even get to the other portion of it.
May I make a comment?
Who is this, please?
Ms.
Attorney
Guzzo.
Peggy Guzzo.
Yes, go ahead, Ms. Guzzo. I'm sorry.
With respect to the sanctions, even without jurisdiction as to whether or not Ms. Linehan, as a state central committee member or candidate, has violated it, the very fact of bringing a complaint that you don't cover would be frivolous. So I think that you would have jurisdiction to determine somebody who put under oath, under affidavit, under subject to penalty of law, submitted something that was not for the purpose of election integrity, not for the enforcement of, or for violation, but for another purpose, which was to use in their subsequent campaign literature that they were under or subject to the Ohio election violation, which they did, and we submitted that in our response. I would just like to add that, but I would also like the opportunity. There's a couple other statements that was made, and I apologize, but I just wanted to put it for the record if I could, and then I'll let you guys get back to your deliberations. But Mr. Roberts had said that Ms. Linehan had been found to violate a previous statute of 3517.2122 in 2014. But that is false, and I think that we request that be stricken from the record because she was not found to have violated it. This commission actually found that she did not violate it. And then subsequently in 2016, 2 years later, the United States Supreme Court found that those provisions themselves were unconstitutional. Thank you.
Thank you, Ms. Guzzo. All right, Commission, what's your pleasure?
I think this this complaint was filed alleging that the respondent did not include a proper disclaimer. The respondent responded saying, I did not include a disclaimer because under the statute, I am not considered a candidate. I think it's properly before this commission. I think we ought to rule on it.
Thank you, Mr. Brummer. Anyone
Before
else?
before we
Scott?
proceed, I believe Mr. Richter might have switched computers with Chris, and I'd just like confirmation that he is back on the record with us.
Yeah, fortunately, I was able to never leave since between the audio there and the audio on mine, I was able to listen throughout the entirety of everything. So,
Okay.
yes, I am here. That wasn't me.
Any other thoughts by the commission on how to proceed?
This is Commissioner Norman. I move we find no violation.
All right, we have a motion that's been made by Mr. Norman to find no violation. Is there a second to that motion?
Second, Tavares.
Rom.
All right. Ms. Tavares was the second. Any further discussion with respect to the motion? If not, all in favor of the motion to find no violation signify by saying aye or raising your right hand. Aye.
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 Opposed, same sign. Motion carries unanimously. All right, now that we've found that the allegations have not been proven, let's move on to the issue of whether or not sanctions in the form of reasonable attorney's fees is something that we want to consider and rule upon.
This is Commissioner Norman. Based upon what Mr. Richter indicated, that we only impose, or the commission has historically only imposed it with the most egregious, I would not be in favor.
Okay. Anyone else on the commission want to be heard on that? Is there any motion to be made?
I would argue that no, there's not. If the commission's not going to take that
No.
action, there isn't necessarily an action to say we are not going to. But if the commission would decide to do so, it certainly is, clarifies it for the record.
That's exactly what I was doing, to find out if there was any motion to be made with respect to the sanctions. I hear no motion. All right, therefore, there will be no decision then on the sanctions issue. Any other questions or comments? Any other thoughts?
Is there I had asked that there be a motion, Attorney Peggy Guzzo, sorry, that it'd be stricken from the record, Mr. Roberts' comments that Ms. Linehan had been found by this commission to violate this section 3517.21 in 2014, because that is not correct. And Mr. Richter probably could look at the record to validate that as well.
Let's have Mr. Richter go ahead and take a look at that. Mr. Richter, do you have any kind of response to what was said back, or what was done in 2014? Yes.
Immediate, I would say no.
All right.
Because I don't have those materials up in front of me. Not that I couldn't get them here in a relatively short period of time.
Ms. Guzzo, what we'll do is we'll have Mr. Richter go ahead and look back into the archives 2014 and see what was said and what the decision was, and then we'll make a decision on that at the next meeting. Okay.
Yes, thank you.
Bill,
Thank
I've
you
got a question. In the 5 years I've done this, I've never seen anything stricken from the record. Is that something the commission typically or has ever done?
Very, very, very rarely is the best answer that I can provide to you at this point, Mr. Norman. It is not, generally you get into a hearing, where maybe something was presented to the commission and a presentation is made, and there might be something there, but beyond that, no. The commission has generally not tended to take that kind of an action.
I would just add for the commission then, if we as attorneys are before this commission, you rely on the truthfulness of our statements and what we present. So I would ask then that you would ask Mr. Roberts, what was his intent of making such statements? Does he have proof of those statements? Or was it intended to mislead this commission?
I don't think that's our role.
I don't think that's in order at this point in time. Ms. Guzzo, I understand and appreciate your positions. We've asked the executive director to go ahead and take a look at it And let us find out a little bit more about the background before we go ahead and proceed. So I think for right now, that will conclude the hearing for this morning, unless there's anything else that needs to be said to make the record.
I agree,
Okay.
Mr. Kreitz.
May I say something? This is Melanie Lenihan. I just want to say thank you. Thank you all for being here this morning and for your decision and for hearing it and taking the time. Thanks for serving.
Thank you very much, ma'am. All right. Thank you again, Ms. Guzzo. Thank you, Mr. Roberts.
Thank you.
Okay, the next preliminary hearing on the agenda for this morning is Waddell versus Spletzer, case number 2020D-035. Ms. Cunningham?
Thank you, Mr. Chairman. I will be recusing myself from this case, so I will sign off during the hearing and deliberations and come back on at the next case.
Thank you very much, Ms. Cunningham. All right, Mr. Richter, case number 2020D-035.
Sorry, there we go. I'm back. Sorry. It's not that I've been gone, but just trying to do about 5 things. Mr. Chair, members of the commission, 2020D-035 Waddell v. Spletzer. This too is a disclaimer case where the complainant asserts that the respondent not include a proper disclaimer on certain campaign materials. We received a response. All materials have been forwarded to you as it relates to this complaint that have been submitted. Mr. Waddell is physically present here. You see him appearing under Christopher Hughes' name in the video. I believe counsel is present as well as Ms. Spletzer. And so if the commission would want to hear from the respective parties, certainly has the ability to do so.
All right, Mr. Waddell, are you represented by counsel, sir?
I'm representing myself.
All right.
And he would need to be sworn in order to
Right. If you'd go ahead and
make
do
a
that.
statement to the commission. Mr. Waddell, do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you very much. Please proceed.
Good morning, commission members. Thank you for taking the time to hear my case. I read the brief that the Ms. Sputzer's attorney sent to you.
Can I stop for a second, sir?
I'm not going to
What, just a second,
explain all the
sir.
rules.
Just a second.
Mr.
Mr.
Richter,
Norman?
can you maybe mute your microphone? Because we're getting a lot of reverb here on our end. And I presume because you're both in the same room.
Yeah, I believe that would be the case, and it is done.
Thank you, sir.
Go ahead, Mr. Waddell.
You guys know the rules here very well, and I appreciate what you do. I'm going to make this very simple. I think it's simple enough. When I filed my campaign finance statement, I did ask the Board of Elections if I needed to claim. I also printed flyers myself in a small area. You can do that. They told me that there is a cost involved with the ink, with the paper, and that I should assign a value to my printing of the products and claim that, which I did. Ms. Sputzer's attorney seems to think that there was no expenses by her. She did pass out a handbill that she created. It also does state in 351720 that it must state paid for by the candidate. Just because it says Tessa Sputzer, Third Ward Warrior, doesn't say who paid for the material, who created the material. And I think it's very clear, and I'm not going to take up a lot of your time with this. Thank you.
Thank you, Mr. Waddell. Questions by the commission before we move on to Ms. Spletzer? Ms. Spletzer, are you present this morning, and do you have counsel?
Yes, this is Attorney David Randolph for Ms. Spletzer.
David, good morning. Are you going to be then speaking on behalf of Ms. Spletzer, I assume?
Yes, I will.
Go ahead and proceed, sir.
All right. May I please the commission? This is David Randolph on behalf of Tessa Spletzer. I too will try to keep this as short as possible. In Mr. Waddell's complaint, he cites to a statute that no longer exists, and also cites to a commission's opinion that is 24 years old from 1996 and has since changed in 2012 and beyond. That statute required that business address and residence address be included on multiple handouts or flyers or any campaign material. As of now, the statute requires that the name of the entity appear in a conspicuous place when issuing the communications or publications, and that's located in RC 3517.20B. All the exhibits attached to Lyle's complaint show that Tessa's name, her image, and candidacy name all appear on each and every single one of those campaign handouts. Moving forward in that statute in RC 3517.20F, it requires that a disclaimer paid for by following the entity's name appear. However, there were no expenses involved with Tessa's campaign material. She used her own ink that she did not purchase for the campaign materials. She used a printer at her own home. She used paper at her own home. She did not have to go to a commercial printing or pay large amounts of money to, get these campaign materials created. She created the own materials on her computer using like a Word processor. So that kind of flows into our second defense, I guess, is under RC 3517.105 B1A through B. Again, in the same, sentence, any expense that she had with her campaign were de minimis. And that statute requires anything over $100 to be shown to be, say, paid for by the candidate or someone in opposition or for the candidacy. I would end this on just saying that Mr. Waddell has the burden of proof to show these expenditures exceeded the limits as in the statutes, or they weren't de minimis. His complaint fails to do so, and he cites statutes that no longer exist, which we gave him the benefit of the doubt, trying to respond in a way that used the language as is today. And for those reasons, I would ask that we dismiss his complaint and find no violation for Tessa Spletzer. If there are no further questions, I will rest on the brief.
Thank you. Questions of council? Mr. Waddell, is there anything that you have to say in response to the respondent, council?
Yes, I'll just say this, as I said before, when I bought my ink cartridges, they were $100, and that's not the point. The point is, I filed a complaint with the Elections Commission. They sent my complaint back to me, asked me to affidavit, which I did, and they also sent me all the rules and everything, and I used that, and that's the document that I got from the commission. That's the document I used. The Board of Elections tells you it has to say paid for by, and if it says paid for by candidate, that's acceptable. It does not say that on there. There is a cost involved. It may be minimal, but there is still a cost involved, and it does not have a disclaimer on it, and it's just, that's the simple part of it. It doesn't have a disclaimer. Tessa Spletzer, Third Ward Warrior, doesn't say anything more than who she is.
Thank you, Mr. Waddell. Mr. Richter.
Mr. Randolph, yeah, easy for me to say.
Phil, you need to unmute your mic.
Would help, wouldn't it? Although you're getting it through the other computer. Mr. Randolph, did Ms. Spletzer have a campaign committee?
She did not.
She did not. She ran totally on her own. So she did not have an entity per se. And she did not go over either $1,000 or $2,000 in her campaign expenditures?
That is correct.
But she did include her name on all campaign materials?
That is correct.
Okay, thank you.
Thank you.
Any other questions or comments by the commission? Mr. Richter, do you have a recommendation?
Yeah, you see my recommendation to find no violation. The statute obligates, if there's an entity out there, a campaign committee, that should be on there. It's generally accepted that as long as the candidate's name is on the material, that's satisfactory to meet the disclaimer requirement. I appreciate, historically, the commission has found that if the materials are properly otherwise notified or noticed and disclaimed, if the words paid for by are not included on the materials, that the commission has not found a violation for that situation. My recommendation of the violation is all these materials appear to have Miss Bletzer's name on them. They include also the phrase Ward 3 Warrior, whatever that is. And so therefore, I believe there's been compliance with the statutes.
Thank you.
Commissioner Norman, move to find no violation.
All right, we have a motion to find no violation. Is there a second?
Second, Commissioner Brammer.
Second by Mr. Brammer. Further discussion on the motion? If not, all in favor signify by saying aye. Aye.
Aye.
Opposed, same sign. Motion carries 6-0. The record noting the recusal of Ms. Cunningham on the vote. Thank you very much, Mr. Waddell. Thank you very much, Counselor. Appreciate your arguments this morning.
Thank you very much.
Thank you, Commission.
Moving on to the third preliminary hearing this morning. It's case 2020G-034, Sullenberger versus Friends of Zach Dickerson et al. Mr. Richter?
Yeah, this case involves a complaint that alleges that the respondent accepted a contribution of greater than the $100 cash limitation on campaign contributions as identified in Revised Code Section 3517-13F. We received a response. All materials have been forwarded to you. The respondent states that, yes, he did accept that cash contribution. It was an error. Once apprised of the error, a refund of $400 was made to the contributor to bring that down back under the amount. He said he immediately sent that out for some reason. The Montgomery County Board's website, in his statement at least, did not appear to upload the addendum he reflected. So that's why respondent did not see that in a more timely manner. You can see I am show participants here. I am not certain. I am opening up my listing of attendees. I don't know whether Mr. Dickerson or Ms. Sullenberger are present today. I'm looking through my my list. It doesn't appear so. So it doesn't appear that either party is present.
Is there anybody present out there this morning on case 2020G-034, Sullenberger versus Friends of Zach Dickerson et al?
Okay.
That would seem to confirm your position. Yeah.
My recommendation is to find a violation, oppose a fine of $100.
Okay. Questions, comments by the board, commission? If not, I'll entertain a motion.
I make a motion, we concur with the executive director's recommendation, find a violation, and impose a fine of $100.
Do we have a second to that motion?
Second.
Beatty.
Oh, let Mr. Beatty take it.
All right, the second by Commissioner Beatty. Further discussion on the motion to find a violation and impose a fine of $100. All in favor of the motion signify by saying aye or raise your right hand.
Aye.
Aye.
Opposed, same sign. Motion carries. Thank you very much. Okay.
Thank you.
If I correct, that concludes the preliminary hearings for this morning, Mr. Richter?
That is correct, Mr. Chairman.
All right, well, let's move on to our hearings. We have two this morning. The first hearing would be case 2019R-318, 2020R-057, 2020R-058, 2020R-059. All four of those cases are captioned Cuyahoga County Board of Elections versus Mr. Elkins, the Elkins Committee, and Bernadette Weaver, Treasurer. By way of background, this matter came on for hearing before the Elections Commission on March the 25th, 2021. All four cases were consolidated for hearing and determination purposes. Both parties had an opportunity to present evidence, answer questions, and make summary arguments before the commission. The matter is now before the commission for final determination. Mr. Richter? Counsel for the complainant, Mr. Sims, is present this morning. And counsel for the respondent, Mr. Rupert, I believe is also present, correct? Can we confirm?
That is correct. Both parties, I believe, Mr. Rupert, it was present earlier. I'm looking through my list. Oh, okay. Hi, Jeff. So yes. Oh,
Okay.
And
this
Janine
stage,
Plummer is here as well. And so is, I believe, Amy Hott.
Thank you very much.
I have a procedural question, Phil. At this stage, we're here to just have a discussion among commission and make our decision. It's not a matter of argument, correct?
That is correct. Making sure I was unmuted. Yeah, that is correct. We closed the evidence at the conclusion of the meeting. Well, not at the conclusion, but we closed the evidence, the presentation of evidence at the last meeting. The commission conducted some deliberations and then determined that it would take additional time to consider the matter in the intervening period. I have prepared certain materials and circulated those to commission members for comment. In addition, individually, I've talked to some commission members about how this matter would proceed. And so we are now here to make a final determination of, whether there's a violation or not. And if the commission finds that there is a violation, what is the appropriate sanction from the sanctions that are available to the commission? I provided comment to the commission members on that as well. But, the final decision obviously comes down to what it is that the commission wants to do with this particular case and how it wishes to proceed.
Mr. Richter, should we go ahead as a matter of procedure and bifurcate this proceeding? First of all, dealing with the issue of whether or not there's been a violation. And then secondly, moving on to what remedy, what sanction the commission decides to impose?
I think procedurally that would make a certain amount of sense, yes, to go ahead and do that, because I based on the evidence presented and where the some of the comments from commission members, I believe the determination of a violation or not should be fairly easy, and then we can move on from there.
Well, I suppose what we maybe should do is just move to find a violation, and then we could discuss it. And I guess I would move that we find that there were 651 violations.
All right, we have a motion by Commissioner Norman that there were 651 violations committed in the 4 cases. Do we have a second to that? There's no second.
Catherine, you're muted.
Catherine,
This is Commissioner Cunningham. I'll make a second.
Okay.
Sorry.
So we have a motion that's been duly seconded that would find 651 violations. Is there further discussion or comments simply on the issue of whether or not there have been violations, 651 violations or not?
And well, I will quickly interject. First off, I presume that means 651 separate violations, as it was presented at the last meeting, of Revised Code Section 3517-13-0, and also for clarification purposes, that those violations are by the individual and candidate and respondent, in this case, Trevor Elkins. Is that correct?
It was my, I want to follow back up on that because it was my understanding that when we consolidated for hearing, that we also consolidated for determination, and that there were three respondents in this case.
There are multiple respondents. I was merely clarifying
Sure.
as to what it is that we're specifically addressing right now.
Understand.
Let me
go back to the motion maker, Mr. Norman. What was your intention?
I'm going to follow up with Mr. Richter on another question then. Would one of those potential violators be the treasurer?
Potentially, yes.
Yes.
Certainly.
As well as the Elkins committee.
As well as the Elkins committee, correct. I mean, they're all before us at this point, correct.
I'm going to amend my motion, and I'm going to amend my motion to say there were 651 violations by Trevor Elkins.
And just simply the individual, is that correct?
That is correct.
All right. Any objection to that? Catherine, you were the second.
No objection.
Okay, no objections, and then the amended motion is that we find 651 violations, 651 violations, excuse me, against Mr. Elkins individually. Further discussion on the motion? All in favor of the motion signify by saying aye and raising your right hand.
Might we do this by roll call?
Good idea. Thank you very much, Mr. Norman. Let's do a roll call on this, please.
Sure, not a problem. Ms. Kaufman,
Aye.
Ms. Tavares,
Yes.
Mr. Bromer,
Yes.
Mr. Beatty,
Yes.
Ms. Cunningham,
Yes.
Mr. Norman,
Yes.
Chair Kreitz.
Yes.
That motion passes unanimously. That's what I was trying to say.
All right, so we now have found Mr. Elkins' violation of 651 counts of section 3517.13 we can move on now to what the appropriate sanction or remedy is.
Mr. Chair,
Yes, go ahead, Ms. Cunningham.
will we also be addressing the Elkins Committee and Bernadette Weaver before we go to penalties?
That's a very good question.
We certainly, I'll interject just to say we certainly can, although the primary, the majority and primary evidence that was presented at the hearing 2 weeks ago obviously concerned Mr. Elkins' activities, et cetera. We didn't hear a whole lot about what the treasurer did or didn't do, aside from the fact that Mr. Elkins indicated that, as I recall, Mr. Elkins indicated that the treasurer was his mother, I believe, and primarily signed materials prepared by him and did not have a lot of other activity. And so, I think certainly we need to take that into consideration. Additionally, again, the primary thrust of the presentation 2 weeks ago was concerned what Mr. Elkins did and his activities through the campaign, but also individually. And so I'm in my own mind, I'm not clear what all we have as it relates to violations by the campaign committee, aside from what Mr. Elkins did.
And this is Commissioner Norman. I put it before the commission as a motion only as to Mr. Elkins, because ultimately, if we decide that we're going to impose a fine, I did not want the ability to run it through the guise of the commission as opposed to coming from Mr. Elkins, who I believe was the one who perpetrated these 651 violations.
I understand completely what's being said, and I think as a matter of procedure then that we need to take some sort of an action as a commission to indicate then that we're not taking any action against the Elkins committee or against Bernadette Weaver Treasurer, if that's what I'm hearing you'd like to do. Because right now we have three parties defendants. We've acted on one. There's still two out there. As a matter of procedure and as a matter of having a clean record, I think we need to take action one way or another with respect to the committee and as to the treasurer.
Mr. Chair.
Ms. Cunningham.
I would say from my perspective, I think that both the committee and the treasurer had statutory duties, that there was no evidence that they did not violate. There was evidence that those duties were violated in terms of keeping clear accounting and all of that. I don't disagree with what Mr. Norman is saying. Not sure that those were the primary actors, but I'm not sure that we can absolve a treasurer and a committee from taking no action when that is going on. Whether we do our penalty and fine differently is another question. But from my perspective, I understand that they put on very little defense, but there is stipulated evidence that there were continued violations of accounting and deposits and withdrawals from an account, which was in the name of the committee and the statutory duty and responsibility of the treasurer.
Mr. Chairman,
Yes.
Chairman, this is
ahead.
Commissioner Tavares.
Go ahead,
I would
ma'am.
agree with Ms. Cunningham for several reasons. It's really supposed to be a checks and balance between the candidate or the issue campaign and the treasurer, so that you have someone who is checking on those expenditures and also the revenues that are collected on behalf of either that issue or that candidate. So I agree that there are statutory responsibilities of the treasurer and the campaign itself.
Yes. And I would agree with that as well. Couple that with the fact that everyone received notice in this case, had an opportunity to appear, and the fact that there's been no evidence maybe provided by Ms. Weaver or by the Elkins Committee. I think we can still go ahead and find them liable under the Ohio Revised Code.
Mr. Richter, can we procedurally move forward and discuss Mr. Elkins and what we are going to determine as a penalty for his violations before we move to the other two?
Yes, but I'll answer that one simply. I believe that would be the case. Certainly, we could also make that kind of a finding against the committee and treasurer, impose some sort of sanction there that we deem appropriate, and then still take up Mr. Elkins. We've made that finding against him, so that's done and over with. And it may be best to go ahead and make an initial finding of a violation of some of the other provisions, the 3517, 10 and 13 provisions concerning improper reporting, essentially, against the committee and the treasurer for their responsibility. Certainly, also the treasurer does have certain responsibilities because the statute under 13.0 does say no beneficiary of a campaign fund or other person, and so therefore the treasurer would certainly fit the description of other person under that provision.
I would move that the Elkins Committee and Bernadette DeWeaver also violated the statutes, and we should make a finding that they did violate said statutes.
Is there a second to the motion?
Cunningham, second.
All right, we have a motion that's been duly seconded to find that both the Elkins Committee and Bernadette Weaver Treasurer have also committed violation of the Ohio elections law. All in favor signify by saying aye or raising your right hand. Aye.
Aye.
Opposed, same sign. Motion carries.
Motion passes unanimously.
All right. So we now have made findings as to the Mr. Elkins individually, his committee, and Ms. Weaver, the treasurer. Now we move on to the issue of what sanction, if any, needs to be invoked.
Well, I'll start off. This is Commissioner Norman. Last time we discussed the potential of either keeping it here, imposing a fine, or referring it for prosecution. We didn't have enough discussion to come up with a consensus. I've had considerable thought and discussion with Mr. Richter about whether or not we can impose a fine, and if the fine is not paid, whether we can then pull back and refer it for further prosecution. And I think as I review the statutes and as I look at it, I don't think we can do one and then do the other. I think we either have to impose a fine or we have to refer for prosecution. And I don't know how everybody else feels about that. I guess maybe that's the first discussion.
Ms. Cunningham?
Thank you, Mr. Chair. I agree with Mr. Norman. I think we choose a fine or we choose a referral to prosecution, but I don't think that one of the conditions of the payment of a fine can be if you don't pay it, we're going to refer it to prosecution. I think you've got to decide that at the initial determination of the penalty. And I will say from my perspective, we've got prosecutors requesting referral for prosecution and fairly egregious violations, and I'm in favor of referring for prosecution.
Other commission members?
Well, I think I said, Mr. Chairman, I said 2 weeks ago that I believe the issue is before the Ohio Elections Commission. As such, I believe it's incumbent on us to handle this issue and not simply refer it for prosecution. I think we should be able to agree on a fine, I said 2 weeks ago, commensurate with the scope of the violation, and that's still my position.
This is Commissioner Norman. I've been on the commission. This is concluding my 5th year. I've never seen a case this egregious, this bad. And my concern is if we impose a significant fine and it doesn't get paid, we've now imposed a penalty that has no teeth. So I've gone back and forth. I'm torn by what I really think should happen, but I think I'm leaning toward referring this for prosecution so that people realize if they're going to try to do this, that they're going to be subject to further penalties that they can't just avoid.
And prosecution can include fines.
It can.
In an M1, you know.
Especially when you're talking about 651 violations.
Well, as I think I made it clear the last time we met, I feel very strongly that this case needs to be referred for prosecution. I mean, we've found 651 individual violations of accessing campaign funds for personal use. We're talking $134,000. We're talking about over a period of 2015 to 2019. I mean, these are serious violations. I mean, this gentleman's had a history of being in public life since at least 2004. He has a history before this commission. He's gone ahead and admitted the fact that he committed these 651 individual violations. This is, as I've indicated previously, and I would agree with Mr. Norman, probably the most egregious and blatant violations that I've seen since my tenure on the commission. And I strongly still believe that this case needs to be referred for prosecution. Are there any other comments or discussion to be had by the commission before we entertain a motion?
Yes, this is Commissioner Beatty.
Go ahead, Mr. Beatty.
Yes, to the Executive Director, Mr. Rector, we've had this discussion several times, but insofar as the Ohio Attorney General's history in enforcing our fines, could you speak about that? And were there any examples where they've really taken some strong actions to enforce a fine against a individual or campaign which was found to be in violation?
And Phil, can you open up your video if you would?
It is open, and I am, according to my, on my side, I am showing my face, and I can see me.
I'm just getting in it. I apologize.
That's okay. So, I mean, there's nothing else I can do.
Okay.
First off, we've never had assuming we were to impose a substantial fine here, and it is not paid, and then we would have to send it along to the Attorney General's office. We've never had that kind of a case before here, aside from the All Children Matter case, in which the commission imposed, essentially $2.6 million in fines over to two different committees, not necessarily individuals, and that was not ever. There was nothing ever essentially collected on that. That's in its own little bailiwick. I would have to say that in general, the Attorney General's office works diligently to try and collect matters. It sometimes takes time for them to do so. We've seen a real mixed bag of responses. In some cases, they have sent out to the special prosecutor, and special prosecutors gotten substantial monies back. There have been other times, though, where things have lagged for an extended period of time. Certainly, if the commission were to impose a substantial fine here and it is not paid, it would be dutifully sent along to the Attorney General's office for collection, and I would include to them all materials and as it relates to the findings by the commission and what has gone on, in an effort to try and encourage them to strongly pursue to make sure that the fine amount by the commission is properly and timely collected. But it's hard to really say that they have been overly aggressive. I think they've been generally, okay and pretty good, considering they're not only working with us, they're working with all other state agencies to try and collect outstanding amounts. But this case would be much different than anything else that we have ever had.
I have a further question, having not been involved in it from the collection standpoint. Did they have the same abilities? Let's assume I'm in a civil court and I've gotten a judgment to be able to go and attach liens and try to force foreclosure and do those kind of things, should they choose?
I believe the simple answer to that is yes. They have all of that available to them as they go about trying to collect amounts from the commission. And one of the things that they've been very successful with over recent years is attaching tax refunds. We have seen a great increase in that over the last, I'd say, probably 10 years. As you know, if we are able to discern a social security number and send that along to them, they've had good success in doing that in an effort to try and claim some monies.
If we refer a matter to the AG for collection, do they listen to you as our executive director saying this would be more of a priority as far as collection than some of the other maybe less meaningful cases?
I believe that they would, yes, because even though we were never able to collect anything on All Children Matter, they did start proceedings in court in an effort to try and collect that. We had meetings with the judges, in an effort to try and arbitrate the matter and mediate the matter. And so they were very aggressive there when it came down to that. And so I believe if we were to impose a substantial sanction and it not be paid and then matter referred along to them, I would certainly be more than, I would expect myself to make sure the point to them is made that this is an extremely important matter to the commission, and that we strongly want to see this matter collected to the full extent of the law available to them. But I know that from talking with at various times over the years, from having talked to special counsel when they send something like that out, the special counsel works aggressively because if they collect it, they get a portion of what is collected, and so it's in their best interest to try and be aggressive as it relates to collecting the funds.
I know Mr. Beatty asked a question and we've not heard from Ms. Tavares or Ms. Kaufman. I guess I'd like to hear what you guys are thinking and what your opinions are.
This is Commissioner Tavares. I would agree with both Ms. Cunningham, Mr. Norman, that it should be referred for prosecution, and we can deal with the other two entities in separate actions.
Ms. Kaufman?
Initially, and I've thought a lot about this past week and just reviewing the materials. Initially, I believe I thought that we should keep it, in-house and do what we thought was best as a commission to set a precedence. But just reviewing it and thinking about it, and quite honestly, it's big. It is egregious in every sense of the word. And I have come to to my opinion of, I agree it should be forwarded for prosecution.
Anybody else have comments to be made on the commission with respect to the Mr. Elkins part of this case?
Just a
Go
question,
ahead, Mr. Bromer. Sure.
Mr. Chairman, of Mr. Richter. If that is what happens and it's referred for prosecution, can you describe what the time period might be for something like that to finally get adjudicated? And what would the possible outcomes be, could be? Maybe you can't tell, but.
That would be hard for me to respond to, because certainly, first off, I'd have to get them all the materials, although needless to say, I would work on that quickly and get it to them as quickly as possible. For them to take action, then they'd have to take it to court, and whether they would need to go through a grand jury or some other proceeding, I don't know the answer to that, as to how fast and or how quickly. Obviously there are constitutional prescriptions in terms of moving this thing moving it as fast as possible through the court system once it gets there. Could be, we could see from Mr. Sims and or Ms. Hummer if they have any information that they can provide the commission as it relates to any kind of timing issues that would be better coming from them than me, considering they're the ones that are going to be, at least as prosecutors, they have more direct understanding of that than do I.
And I guess this is Commissioner Norman. If they're going to be just prosecuted as individual misdemeanor counts, then you wouldn't have to go before a grand jury because it would just be brought as misdemeanor claims and it would be each violation. If the prosecution's office is going, because of the mass and the magnitude and the egregious conduct here, they want to submit it. Now you're talking about felonies, and now you're up to the mercy of a grand jury, and then you're up to the mercy of, and Mike, you're probably at a significantly better position than the rest of us because you've dealt with this.
Sure. Well, generally, you're correct. Generally, misdemeanors are not presented to the grand jury, but they can be presented to the grand jury. I think what will happen if it's referred is that the prosecuting attorney will assign an assistant prosecutor, or in this particular case, since we already have assistant prosecutors that are assigned to the case, they may take over the case. They'll go ahead and issue subpoenas, interview witnesses, and then make a determination of whether to present it to a grand jury. I don't know how long that will take. I guess it just depends upon questions the grand jury may have. These kind of things don't drag out for years, I mean, at the county level, but there could be several months before it's actually heard.
And once we make a referral, quite frankly, it doesn't matter how long it takes.
Doesn't matter. It's their call.
It's up to the prosecution.
That's right.
I had seen some discussion about whether we can refer this specifically to Franklin County Prosecutor's Office or the prosecutor in which his home county. Do we have Mr. Richter, do we have the opportunity to say we'd like it referred to the Franklin County Prosecutor's Office? Yeah,
the statute that talks about prosecution that the commission has available to it, 3517-155, I think it's A2. Says that it's an either or proposition, either the Franklin County prosecutor or the prosecutor in the office, the prosecutor in the county in which the activity has taken place. So, we could either refer it to Franklin County or to Cuyahoga County. That's our, we have that discretion.
And if memory serves me from the hearing, and when we heard from Mr. Sims, and I believe maybe Ms. Hummer as well, they would probably still be the same team that would handle it. So it would seem that if we're going to refer to the Franklin County prosecutor so they don't have to travel and waste more time and effort on this.
I would agree. Makes more sense. Economy of resources.
Yeah, and certainly they have, the Cuyahoga County prosecutor originally asked them to act as special prosecutors in this case. And so, presumably there wouldn't be an issue from Cuyahoga. I certainly can't say that, but presumably the Cuyahoga prosecutor wouldn't have an issue with us sending it to the Franklin County prosecutor, considering all the efforts that they put into it to this point.
Thank you.
Are there any other questions, any other comments to be made before we entertain a motion? Do we have a motion to be made?
Hang on, so I look like Ms. Coffin might have had something she wanted to say.
I'm sorry.
No?
No.
Okay.
It's just, it's big. It's a big case, and it, I guess, deserves all of our thought, and that we've all put into it all this past week. So it's big.
All right, thank you. I'll entertain a motion at this time, if there is one to be made.
This is Commissioner Norman. I move that we refer this matter to the Franklin County prosecutor for further prosecution.
All right, do we have a second to the motion? Ms.
Catherine,
are you on, Ms. Cunningham?
Cunningham, second. Sorry.
All right. We have
I was muted.
That's all right. We have a motion that's been duly seconded that would refer this matter to the Franklin County prosecuting attorney. Further discussion or comments with respect to this motion?
We'll
do a roll call vote.
Mr. Chair, was that motion related specifically to the respondent?
Mr. Elkins.
Candidate, Mr. Elkins, yes.
That's correct. Thank you.
Correct.
Let's do a roll call vote, Mr. Richter.
That is fine. Ms. Tavares.
Yes.
Ms. Kaufman.
Yes.
Mr. Beatty,
No.
Mr. Bromer,
No.
Ms. Cunningham,
Yes.
Mr. Norman,
Yes.
Mr. Chair Kreitz.
Yes.
That motion passes 5-2.
All right. Motion is passed 5-2 to refer this matter with respect to Mr. Elkins to the Franklin County Prosecuting Attorney. Now, we still have the committee and the treasurer. How would the commission like to proceed with respect to those two entities, individual?
I don't know whether, I'll interject just to say, I don't know whether it would be considered nominal or not, but certainly I don't believe that good cause is present. And I don't know that, I mean, certainly if the commission would like to prosecute, we could certainly do that as well, but it doesn't appear that that would be a sufficient. It certainly would appear that some sort of a financial sanction is appropriate under this set of circumstances.
Do you have a recommendation, Mr. Richter?
Mr. Richter,
I'm sorry, I couldn't hear you.
What were you saying, Mr. Norman?
I said I have an opinion.
Well, I'll throw out $650. We'll see what Mr. Norman has to say.
Mr.
I
Norman?
look at it and I go, it's a 5-year pattern of repeated history where the committee is allowing somebody to dip their toes and steal from it. The treasurer does nothing. I was thinking more in the lines of $5,000 each.
Okay. Anyone else wish to be heard on this?
I just want it noted, when we were reviewing the case a couple weeks ago, in 2015, Mr. Elkins was listed as the treasurer. So when there were items that were submitted and reports that were submitted. So I don't know if that takes Mrs. DeWeaver out of the equation for at least that year. But I know that when I was reviewing that, he was listed as the treasurer for that year. So I just felt like that needed to be said. So it's, it's not saying, to diminish what was done, but, that's just one year that maybe needs to be taken out of consideration.
Thanks, Natasha.
Mm-hmm.
Ms. Tavares, I know you were a previous candidate. I'd like to hear your opinions on this.
Yeah, I would agree with Ms. Kaufman that 1 year that Mr. Elkins was in fact the treasurer. In many cases, candidates have been their own treasurer. It's not wise, but my concern is that even after a new treasurer was identified, which happens to be the candidate's mother, that the candidate himself still controlled the treasury. And so, is she negligent? Yes, because she allowed her name to be used as treasurer, and with that, she took on the responsibility. So should there be a fine, a violation? Yes. I'm still debating on what that fine should be, but she committed to being named as treasurer.
And I appreciate your opinion. That's why I asked for it. And as I look back on it now, obviously, I know many of us are parents and do things for our kids. So I would be inclined to say maybe I'm going to adjust my opinion as it relates to her being the treasurer as opposed to the committee.
I agree with that.
Yeah, I note that I don't disagree with anything anyone is saying. She was designated as the treasurer in 2011, and she did sign a lot of the reports that went in. How much she was actively participating or just lending a scrivener's hand to reports others were preparing. I think that most of the testimony was that Mr. Elkins was preparing the reports and his mother was signing them. So I agree with Commissioner Tavares and Commissioner Norman and Commissioner Kaufman that that's not the same as the candidate using a campaign account as his personal bank account. But it is also I think we have to attribute some responsibility to people who allow themselves to be designated as treasurer, and then this happens under their watch.
Any other thoughts? If not, then do we have a motion?
This is Commissioner Norman. I move we impose a fine against the Elkins Committee in the amount of $5,000, and we fine Ms. DeWeaver in the amount of $500.
Okay, do we have a second to that motion?
Cunningham, second.
All right, Ms. Cunningham has seconded. So we have a motion that's been duly seconded that would impose a fine of $5,000 with respect to the Elkins Committee and a $500 fine with respect to the treasurer, Ms. DeWeaver. Further discussion or comments from the commission? Mr. Richter, let's do a roll call.
Not a problem. Mr. Bromer,
Yes.
Ms. Tavares,
Yes.
Ms. Kaufman,
Yes.
Mr. Beatty,
Yes.
Ms. Cunningham,
Yes.
Mr. Norman,
Yes.
Chair Kreitz.
Yes,
That motion passes unanimously.
thank you very much. Mr. Richter, do we have anything else with respect to the Elkins matter?
I believe we have dealt with that fully.
All right.
The other thing I would add is, is the commission satisfied with the determinations that it has made here? Or did it want to put into writing anything outlining its findings as it relates to this matter?
I would ask for guidance from the executive director.
Similar, I mean, I have prepared and circulated, materials, over the last week or so, kind of laying out what I thought were some of the essential and critical findings. And is that a written decision that the commission would like to include as a part of its conclusion of this case?
This is Commissioner Norman. I think based upon the egregious nature of what we've seen and the fact that we are, I think, precedent setting here, I think it would be beneficial for commission as it moves forward in the future that we do have an actual written opinion in this regard.
Mr. Executive Director, my question relates to the timing of the issuance of that decision. I know we had timing, memorialization in writing, I would say. I know we have statutory timeframes in terms of the timing in which we have to make a decision. Do those timeframes apply to the written decision? And do we need to, obviously it's going to have to be amended to reflect what the commission did. And would we then need to schedule a special meeting for giving the commission members the opportunity to review the written decision and come back together at least for a vote on the issuance of it?
Well, at this point, we would, generally speaking, and certainly if the commission would want me to do so, I could refer to the prosecutor. Now we've made our decision, but our process has historically been waiting to send out disposition letters and taking those kinds of actions until after the minutes are approved, which would be at the next meeting on April 22nd. I could easily have the written decision prepped and circulated to everyone in advance, and then ready for if the chair, presumably the commission would direct the chair to sign it, but I could have that available at the next meeting for the chair to sign, with everyone having an opportunity to review that in the intervening period. And that would fit within the 30-day period that we instituted on March 25th.
So yeah, that was my thought. We had 30 days from the 25th and our next hearing is on the 22nd. So that certainly puts us squarely within the 30 days.
Correct.
Okay.
And I would encourage the commission to establish, some of the things that it found and the bases for its determination. In this particular case, I believe that such a finding by the commission and has been helpful in other circumstances when the commission has found its decisions appealed, and it could be helpful as it relates to presentation to the prosecutor as they proceed on this matter.
Thank you.
Do we have to move in that fashion, or are we just, that's how we're going to do it?
I think if you just direct me to prepare that, I can have it prepared, circulated to everyone, and have it ready and have it in the chairman's hands at the next meeting so that he could sign an original for that matter. And then we would include that with the materials that we send to the prosecutor's office that I would have essentially ready at that time.
Well, if we approve it at the next meeting, which is April the 22nd, you could use my electronic signature, couldn't you, Phil?
I could, but I just wanted to
and I'm glad to sign
cover
in
all
person too,
bases.
but
Yeah.
okay. All right. Anybody have any objection to handling it that way then?
I have, this is Commissioner Cunningham. I have no objection, but I would request that we get it as soon as possible because
Right.
just the timing of review takes me a minute.
If not,
How quickly can you turn that around, Mr. Executive Director?
if not tomorrow, early next week.
Okay. That
Okay.
would be fine. All right. Any other comments with respect to this matter, the Elkins matter? All right, then for the record, that would conclude our handling of the Elkins matter. To everyone that's present this morning, thank you very much for being present, and also thank you very much for the presentations which you made at our last commission meeting. So again, thank you very much. All right, let's move on to the final matter that we have on the docket this morning. It's Duralia versus Protect Geauga Park et al. It's case 2020G-008. Mr. Richter, do we have counsel present? Yes, I'm sorry.
This is Scott Norman. Any chance we could just take a 5-minute break?
I have no objection. Do we want to take 5? You want to make it 10?
5 is fine. It won't take me long.
All right, let's take, it's,
20.
I have 11:40 right now. Let's reconvene at 11:45.
Thank you, sir.
Thank you.
Sounds good. No kidding.
Going on, yeah.
What?
I'm going on right now.
Can I can't come in.
Mr. Richter?
I'm a minute late. Sorry, Mr. Chairman.
Well, I've already held you in contempt. We're just trying to decide what the penalty is.
Make it appropriate because my activities were egregious.
Okay. Do we have all commission members back on board, Mr. Richter? I see Catherine, I see Scott, I see Natasha.
I don't see, I am not seeing
Is Dennis?
visuals from either Charlita or Otto. Dennis is there.
Dennis is?
Charlita and Dennis are both here.
Yeah, I don't see Otto. And Otto's there. Okay,
Otto's
then I
there?
guess everybody's
Okay.
present. I'm not seeing pictures. The only thing is when we go and I actually
Microphone.
make the, there you go. When I do the video and we actually do the video, everybody's picture appears on the videos, even if I'm not seeing them as I'm looking at this right at the moment.
Okay. All right. Well, we're back on the record at 11:47 in case number 2020G-008, Duralia versus Protect Geauga Parks et al. Record should reflect that all commission members are present. Mr. Richter?
Mr. Chair, members of the commission, the complainant here asserts that the respondent acted as a political action committee by actively campaigning against a candidate but did not file a campaign finance reports. Materials were included in the complaint. There was a response submitted as well earlier in the, and so all of those materials were provided to commission members. I see Mr. Duralia is showing up at least in my picture, but he is represented by Attorney Jay Crook. The respondents, Project Geauga Parks, is represented by Susan Schutzow, who was also present today. There were exhibits provided by Ms. Schutzow to me earlier in the week that I sent to you with the materials for the meeting. One contained exhibits 1 through 1. One document contained exhibits 1 through 6, the other 7 through 15. Just this morning, I received an email from Mr. Crook that contained a variety of exhibits that he may use in the hearing today. I forwarded that email, so look in your email inbox. There is an email there. In my conversation, primarily with Ms. Schutzow, she had concerns. I have concerns about sharing screens as it relates to identifying documents, so we thought it best to provide the actual documents to you in the manner in which we did through PDFs. I have also asked Mr. Hughes to be prepared to identify documents and share the screen from his perspective as Ms. Schutzow is unable to do so. So just kind of a procedural thing there. But all parties are present. Counsel for parties are present, Mr. Chair.
Okay.
You understand the basic allegations, a violation of 351710 in terms of not filing a designation of treasurer, not creating a committee, not filing campaign finance reports. That is what is before the commission today for consideration.
Thank you very much, Mr. Richter. Mr. Crook, good morning. Are you ready to proceed?
I am. Thank you very much.
And Ms. Shutow, are you ready to proceed? Ms. Shutow?
Ms. Shutow, I'm guessing she was,
I saw her name.
yeah, her name is still included there. Maybe she's currently muted.
All right, let's just take a moment till I'm sure that counsel for the respondent is present and ready to proceed.
Spotlight. I'm going to spotlight Ms. Shutow.
Okay.
She's
And
muted.
she is muted right at the moment. Ms. Shutow, you're muted. You may be able to hear us. We can't hear you. The chairman has just
Upper right-hand corner next to your camera, there's a microphone. You need to click on that. That should unmute you.
Got
There
it.
you go.
You can hear me now?
Yes,
Okay.
we can.
So
Okay.
sorry. That's
No,
why I'm
that's-
not going to try to put exhibits up on the screen.
That's
No,
okay.
that's fine.
Thank you.
Understand, not a problem.
Ms. Shutow, this is Mike Kreitz, the commission chair. Are you ready to proceed this morning?
I am. Could I just make a preliminary comment? I think this is listed as Duralia versus a number of people, but the complaint is only against Protect Geauga Parks. It's not against any of the individuals.
All right, and Mr. Crook, can you confirm that that is in fact the case?
I can confirm that that is in fact the case.
Okay.
The caption, in
Good.
fact, the complaint was just the two parties, Protect Geauga Parks and Mr. Duralia.
All right, so the respondent in this case is Protect Geauga Parks only.
That's correct.
Okay, both parties have agreed to that. All right, if both counsel are ready to proceed, then I'll turn to you, Mr. Crook, and you may go ahead and proceed, sir.
I will defer to the council. I don't know if you prefer openings or not, if I should just go right to witnesses.
Please go ahead.
With regard to an opening, very simply, and I will keep this very brief. You've been on here a while already before we even got to start. This case very simply boils down to what is a PAC, and it really boils down to the application of one particular case, Corsi v. Elections Committee. And the question is going to be, not was it their primary purpose, was it their major purpose? I'm going to argue it was actually, believe the primary purpose. We're dealing with a 501c4, which is an education-only nonprofit, a primary education nonprofit. I believe that the exhibits will show a pattern of attacks on Judge Grandel and a pattern of supporting his opponent. And this pattern includes listing his opponent's information on their website, encouraging people to draw a ballot to vote against Judge Grandel and for Mr. Rambo. And I think one of the most egregious that's been a consistent piece on their website is that they had a link encouraging people and giving them the ability to file judicial complaints against Judge Grandel. Based on what happened last time, I believe they're going to argue that they were an issue, not anti-candidate, and really they're just there to support the parks. However, later postings on their website were well beyond what the parks and had little to no, I guess, bearing on the issue of the parks. And that's, again, from their own screenshots. Their numbers, as far as the information that have been provided as far as exhibits, I believe those show it was a major thrust in 2020. And the other question is, for this body to consider, at what point do you become a PAC? I'm going to argue they were going to PAC all along. But the other question before this body is, can a nonprofit, by their actions, without changing the registration, as a matter of law based on Corsi, become a PAC by simply engaging in more and more activism, more and more pro-candidate, anti-candidate rhetoric? And I believe the answer to that is yes. And I believe that the evidence will show then when it came to the 2020 election, they absolutely crossed over that boundary and became a PAC. And as a PAC, they should have identified a treasurer, identified the committee, et cetera, none of which was done. Thank you.
All right, thank you. I'm going to give Ms. Shutow now an opportunity to make an opening statement.
Okay, thank you. And I do agree with Mr. Crook that the issue here is whether or not Protect Geauga Parks was a PAC. As you know, there are two elements to that. The first needs to be 2 or more persons, and we are not complaining about that. Protect Geauga Parks certainly is 2 or more persons. They are incorporated as a nonprofit corporation and are tax exempt pursuant to 501c4 of the Internal Revenue Code. The issue is, as you know well, I don't need to tell you, that a PAC definition is that there has to be advocacy for an election, for a candidate. And there also needs to be express advocacy tying the criticisms or tying the information to a candidacy. So here, Protect Geauga Parks, and I will certainly be showing that as the, hopefully not the day, but the hours go by, was not created in any way related to Judge Grindel. It was created when the Parks District started to change its mission. The Parks had always had a mission of basically what I want to call passive use, walks, picnics, and conservation, because as you will hear, there are many really important conservation issues out here in Geauga County. That started to change, and the Parks District, as you probably know, let me back up on that, the probate court judge of a county appoints the Parks Board. So the Parks Board are appointed officials, excuse me. And the Judge Grindel, who is the complainant, is arguing, is I believe the only person they are saying that the organization was created to oppose. He appoints the Parks Board and has been very active in the Parks Board activities. So once the Parks Board changed and started to allow hunting, snowmobiling, things that were no longer kind of passive conservation, the organization created to oppose that. Over time, they've developed into a significant education organization and a watchdog of the Parks Board's activities. Now, what I do expect the complainant to put on is a litany of evidence that my client has criticized Judge Grindel, and they have. Judge Grindel has appointed Parks Boards that they do not think are concerned about the interest of the parks, and he has actively taken an interest in the Parks Board and has actively publicized his opinion about the parks and their use, which is different than what Protect Geauga Parks feels it should be. So they have criticized him. But what they are suggesting is that any time there is a criticism of an elected official, if that elected official later decides to run for re-election, that somehow that previous criticism becomes electioneering. That's ludicrous. Judge Grindel did not announce his re-election until his run for re-election until December of 2019. Many of the things that you'll see put on have been criticisms of the judge that have no connection to an election, no recommendation about how to vote. They are criticisms of the judge and the position he has taken about the mission of Protect Geauga Parks. So to say, I mean, it's a ludicrous position to say that if I criticize an elected official today and 5 years from now that official decides to run for election, that somehow all of my critical actions are related to the future election. That just doesn't make any sense, and it's certainly a violation of freedom of speech. What I will certainly also show is that Protect Geauga Parks did endorse when Judge Grindel decided to run for re-election in 2019, and Matt Rambo became an opposition candidate. My client, Protect Geauga Parks, did endorse Matt Rambo, and they did spend a small amount of money to run some ads. Those ads had the proper disclaimer. Their actions were not done in coordination with the campaign in any way. They filed the independent expenditure reports after consultation with the Secretary of State, and they have done everything that they need to do. The definition of a PAC certainly does not apply to them. They were not created in opposition to Judge Grandel. And certainly, Judge Grandel, as you may know, won re-election. The organization did not go out of existence. They are continuing the exact work that they started 6 years ago, and they will be continuing it, whether Judge Grandel is on the bench or not. So that's my opening statement. Thank you.
Thank you very much. All right, Mr. Crooks, you can call your first witness. Want to make sure that person is sworn, and Mr. Richter will do the swearing.
Okay. First witness would be Barb Partington.
I would like to note that Mr. Crooks did not subpoena these witnesses, so you may choose to only allow him to speak to Barb Partington as cross-examination. I know that this is an informal proceeding and I won't push on that issue, but I did just want to make a note of that.
Thank you very much, Ms. Shutel. Mr. Crooks, what was the name of the witness? Barb whom?
Partington.
Okay, thank you very much. Mr. Richter, will you swear Ms. Partington?
You're muted.
I muted myself, sorry. Ms.
No,
Partington, do you
the
swear or
witnesses as
affirm
well.
to tell the truth, the whole truth, and nothing but the truth, so help you God? You are muted as well, Ms. Partington. You need to unmute. Along the top line of the computer, there's a microphone.
Right next to the camera.
Can we unmute her?
Is her camera on? Because I can't see her either.
I
can see her, yes.
I can't see her and I can't hear her.
I can't hear her still at this point. She's still muted, and
I saw her previously. It looked like they were sitting in a garage.
yeah,
Yes,
they are sitting in the garage. Okay.
Our
no.
situation here, can you hear me?
Are you Ms. Partington?
No, I think that's Ms. Schutzow.
I'm
Okay.
Susan Scheitzer.
I think I got it.
You got it? Okay.
Can you hear
There
me?
you go. All right, well, please, yep, I think we can hear you. So far, we can hear you.
Can you see me?
Yep.
No.
Now, again, I'll ask you just, now that would you raise your right hand and do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Okay, you are now sworn. Mr. Crooks will ask you questions. Ms. Scheitzow may ask cross-examination. But, Mr. Crooks, I think you can proceed.
Mr. Richter, I still can't see her.
I can't see her either.
I can see her, so I
can't either, but I don't know the technology.
Yeah,
I
I'm
can
not
see her.
sure. I've got her spotlighted.
Yeah.
Stop spotlighting me.
Yeah, she's on the big screen, but it's just a symbol.
Okay,
It's not-
I can see her now.
Okay, she can see me now. Okay.
Yeah, I mean, I can see her. I'm not sure what else I would be able to do to make her available to you. I've
Spotlighting me now?
spotlighted you. No, you're fine.
Okay, and I can
Yeah.
now see her and hear her.
Okay.
I can see her and hear her, but she's frozen.
Oh,
And I
okay.
can hear her, but I can't see her.
Oh,
I
jeez.
can both see and hear her. So for once, I am the one who actually has someone available to me. Normally, I'm only seeing a disc that identifies somebody. I'm not sure what I would need to do.
Can you see me? This is Susan Scheitzer.
I can see you.
I cannot.
No, I cannot. I only see an SS symbol on the
Okay.
screen.
Because
Welcome to
we're
the
in the
technology.
same building, we're separated. I could have her come to my computer if you could see me, but
It just depends on who you're talking to. This is Scott Norman, Commissioner, and I can see you, Ms. Scheitzow, but I cannot see the witness. But as long as I can hear them and I hear the testimony, I'm okay.
Let's go ahead and proceed then, Mr. Crooks.
Okay, and, all right. Ms. Partington,
Yes.
good morning, or actually officially afternoon. Could you please state your name, spell your last for the record? We'll start easy.
My name is Barbara Partington, Partington, middle initial Z.
Thank you very much. All right, you are one of the founders of Protect Geauga Parks, are you not?
That is correct.
Okay. And that particular entity, while you listed 2014 on the timeline, it was not incorporated until 2015 as a nonprofit. Is that correct?
That is correct.
Okay. Before that, it was just an informal organization. It had not been in any way codified or memorialized legally, correct?
That is correct.
Okay. All right. So would like to start with, and I'm going to attempt to actually share documents. I think I can do this. Okay. Can everyone see the Protect Geauga Parks, the PDF I have pulled up?
Yes, I can.
Yes, thank you.
Okay, Ms. Partington, can you see that?
I can see the top half of the document.
Okay, I will scroll down. I was actually more concerned about getting it up on the shared, but we've accomplished that, so progress. All right, would you agree with me? Okay, and this has got a title on it. It's a commentary, integrity versus experience, correct?
Correct.
Okay, and the date, February 27th, 2020. You would agree with me that that's the date?
I see that on the screen.
Okay. You've had a chance, you know what things are posted on your website, correct?
I know what things are posted on the website, but you're bringing up something that's from a year ago. No longer visible on the website, but so I can read the document in front of me that you have there.
Okay, so, and this was written by a woman named Chris Steigerwald, correct?
Apparently.
Okay, I'm going to scroll down, and do you see the bottom with it says PGP note?
Yes, I do.
Okay, and that PGP would be Protect Geauga Parks, right?
That is correct.
Okay, and I'm going to give you a minute to read that at the bottom and refresh your recollection.
Mr. Chair,
Yes.
this is Commissioner Cunningham. I don't know whether this is an exhibit, whether it has an exhibit number or how we'll identify it for a future record. So I just throw that out there.
My apologies, and thank you. This is Complainants Exhibit 1. Each of the PDFs has a number in front of it, 1 through 17. So this is Complainants Exhibit 1, and on the PDFs there'll be a 1, 2, 3, and then the title of the actual document.
And Mr. Richter, this is what you forwarded to us this morning at 9:12?
That is correct.
Yes, that is correct. Okay. So, Ms. Partington, can you see the bottom there?
Yes, I can.
Okay. Would you agree with me that this indicates that this particular article and the note indicates that it's not related to the park, but just in general, a statement of negativity about Judge Grendel?
No.
You would not?
I see this is a letter to the editor that somebody wrote to the newspaper. This is not written by Protect Geauga Parks.
It was posted on your website.
That is correct.
And at the bottom, you note that while you state at the start that you've been focused on the negative issue with the parks, it's becoming clear that his overall performance has been devastating to families. So then you explain that you feel that he is performing poorly, not just as a manager of the parks, but as a judge in general, correct?
Mr. Crook, I can't respond to that. I did not write this statement. And the person that wrote this letter is not a trustee of Protect Geauga Parks.
I understand that. This was posted on your website, was it not?
That is correct.
Okay, and this has not been altered. Take as much time as you need. It's not been altered in any way, shape, or form, has it?
I have no idea. I have not seen this letter for over a year.
Okay.
This is a community member wrote the letter.
Understood. And it was posted on the Protect Geauga Parks website, yes?
Yes.
All right. And after these statements that talks about Judge Grendel's poor decisions, and you actually, right following that, you state that you endorse Matt Rambo for Geauga County Probate and Juvenile Court Judge of the primary, correct?
I see the endorsement under that letter to the editor, which I believe that endorsement is under each of the letters to the editor as a separate entity.
Right. And Project Geauga Parks, not Ms. Steigerwald, is the one that put this note on here, correct?
I do not know.
Who manages your website?
We have a webmaster.
Okay. Who submits the information? Who is in charge of submitting the information to your webmaster?
Anybody from the public can submit information to the website.
Okay. Who is responsible for submitting the Project Geauga Parks note?
The webmaster would have created the Protect Geauga Parks note.
Okay. At whose instruction?
I don't know the answer. I have no answer to that. There is that at his own instruction.
Who is your webmaster?
Frank Wertz.
Is he a member of Protect Geauga Parks?
He is a trustee of Protect Geauga Parks.
Okay, I'm going to pull up Exhibit 2. Okay. Do you see the time to remove Judge Grandel from Geauga Parks Oversight previous editorial?
Yes, I do. I see the title.
Okay. Do you see that the publication date is February 25th, 2020? Correct? Okay. All right. And it's a republication of a previous editorial from the Cleveland Plain Dealer, Cleveland.com, correct?
That looks correct.
Okay. Now, and I should have asked this, I'm going to flip back to 1. Go to the top with the date on there, February 27, 2020. You would agree that that was during the primary election cycle, would you not?
Yes, I would.
Okay. And the purpose of posting this was to advocate against Judge Grandel and for Judge Rambo, or candidate Rambo, excuse me.
No.
No. So what educational value with regards to the issue of preserving, protecting, and conserving the Geauga Parks does an editorial that states, that talks about Judge Grandel's political battles and Judge Grandel's proceedings as a juvenile judge has anything to do with the parks?
I can explain that.
Please do.
Protect Geauga Parks is main focus is to influence the park commissioners to go back to the original mission of the Geauga Park District. That is our primary purpose. The park commissioners are the ones that have changed the bylaws and have changed the mission. Judge Grandel, as probate judge of a 1545 park district, is responsible solely for appointing all of the park commissioners who serve at his pleasure. During the election cycle, Protect Geauga Parks chose to endorse Matt Rambo because it appeared to be a good time to try to find a judge that would appoint park commissioners who would have the mission of the park at heart.
Okay, so to be clear, your goal in posting this was to have Matt Rambo elected and Judge Grandel defeated.
Our history has been to post articles that have to do with Judge Grandel. That is why.
I didn't ask you what your history was. I said with this specific article, your intention was to promote the campaign of Matt Rambo and to work against the campaign of Judge Grandel. You were seeking to remove Judge Grandel from office and have Matt Rambo be there because of your belief that he would pick new park commissioners closer to what you believe the mission is. Is that a fair statement?
That is a fair statement.
Okay. And this was posted, obviously, February 27th of 2020 was during the time of campaigning for, it was after Judge Grandel declared, correct?
It was after Judge Grandel. Yes, that is correct.
Yes, and it's after Matt Rambo declared, correct?
That is correct.
Okay, so in the election had not taken place yet. They were both campaigning.
That is correct.
Okay. I'm on to Exhibit 2 with the title. This one is titled "Time to Remove Judge Grandel from Geauga Parks Oversight," a previous editorial. Okay, so the date, February 25th, 2020, Same question as before. This was published during the time that both Matt Rambo and Judge Grendel were campaigning for the position of probate and juvenile court judge of Geauga County.
Yes.
At the top, it says it's worth revisiting as we approach the March 17th primary election, correct?
Yes, that is correct.
Okay. And this was a previous editorial condemning Judge Grendel, correct?
You know, I have not had a chance to reread this. It is definitely a previous editorial discussing Judge Grendel. I do not know if it's condemning him or not.
Well, it says it's time to remove Judge Grendel from Geauga Park's oversight. That, just from the title, it's clearly not in favor of Judge Grendel, correct?
That's speculation. I don't have an answer to that.
If I say it's time to remove a judge in the title of anything I've written, doesn't that give the bottom line up front is I want to remove this judge? Yes?
It's speculation. I didn't write the editorial, or I did not write the title.
Council, we
Okay.
could hear, this is Commissioner Arnold. We could be here all day. Maybe have her read the article and then we can get some more definitive answers.
Okay, let me start with this. This article is posted on your website, yes?
Yes, it is.
Okay. And at the bottom, after that, it says, Protect Geauga Parks endorses and supports Matt Rambo, correct?
Correct.
Okay, so just to be clear, the document starts with it's time to remove Judge Grendel. And the bottom, it says that we're supporting Matt Rambo, who is running against Judge Grendel, correct?
That is correct. It's not part of the article. It's a section added by the webmaster at the bottom of the article.
And the webmaster, who is a trustee of Protect Geauga Parks, who put it on when you posted this on the Protect Geauga Parks website.
Apparently.
And again, this is advocating for Matt Rambo and against Judge Grendel, yes?
I don't know if the article is advocating. Obviously, the statement at the bottom of the article, the Protect Geauga Parks endorsement, is advocating for Matt Rambo.
Okay, would you agree that the articles, whatever the article says is whatever the article says?
I agree with you on that.
Okay. Moving to Exhibit 3, Protect Geauga Parks, again. And this is the timeline from June 17, 2016. Would you agree with me on that?
Well, it was updated in June 17th. It looks like it's the timeline from November 2013, beginning 2013.
Correct, but under timeline, it says updated 2016.
It does say that on the on what you're showing me. Yes.
Okay. So
It's not.
what I'd like, and I'm scrolling down to get to the area I need. So even though there's a bunch of things listed here for 2014, just to be clear, Protect Geauga Parks as a legal entity did not exist at that point, correct?
That is correct.
Okay.
Protect Geauga Parks was a grassroots organization of a number of like-minded people.
Okay. Okay. So that's all I have for that one at the moment. Going to Exhibit 4. I'm going to scroll down so you can see the date and the title. Okay. Would you agree with me that the title of this is End the Culture of Intimidation?
Yes, I would.
Okay. Is Dane Davis a member of your organization?
No, he is not. I have never met Dane Davis.
Okay. Would you agree that the second paragraph talks about the campaign waged by Judge Tim Grendel against Mr. Rambo?
I would need to take some time to read this. I have not seen the letter.
Please do. Please do. And that's, I guess, the way to do it. Just tell me when to scroll down. We'll do it that way.
You can scroll down.
Okay, thank you.
Keep scrolling.
Okay.
Keep scrolling.
Okay.
Hey, I get the idea.
Okay. And again, there's an endorsement of Matt Rambo at the bottom of this that's separate from what was submitted by Dane Davis, correct?
Correct.
Okay. And would you agree with me that this is an argument against any of the against the platforms of true republicanism, experience being important, an allegation of Judge Grandel's petty gamesmanship, and a call to action or an urge for the voters to vote for Mr. Rambo on the 17th of March, 2020?
I would not be able to make those speculations without really studying that letter a lot more to be able to imply what Dane Davis was trying to say.
Okay, this was posted on your website, yes?
Apparently.
Okay. You would again agree with me that the document speaks for itself?
The document is a letter to the editor written by a person named Dane Davis.
Well, wait a minute. Where does it say on there that it's a letter to the editor?
It is my knowledge that that's a letter to the editor.
It says submitted by Dane Davis.
Excuse me, wait, correction. It's a commentary in the local paper, not a letter to the editor. It says it right at the top.
It says commentary, but it doesn't say reprinted anywhere on here with permission of or anything else, does it?
We have a blanket permission to reprint from our local paper, letters to the editor and commentaries.
Okay. So you posted this, you found that you or somebody in your organization found this relevant and posted it on your website, correct?
Correct.
Okay. And again, just to be clear on the date, this was published March 13th of 2020, correct?
Correct.
And the election had not, or the primary election, I should say, had not been decided at that point, correct?
That's correct.
Okay. And again, you're making a clear statement. I understand you're unwilling to address what the article says and it speaks for itself, but there's a clear statement that Protect Geauga Parks endorses and supports Matt Rambo, correct?
That is correct. And I will make one statement about the letter that Protect Geauga Parks encourages free speech. And if people post a letter and ask that it to be posted, we generally post that.
Okay. All right. I am up to Exhibit 5. This was the cover page of the home page of your website, correct? On April 17th, 2020?
That is correct.
Okay. And a car with Matthew Rambo for judge, looks like one of those big magnets, is posted in the scene at the very front of the page, correct?
That is correct.
Okay. Just to be clear, you rotate out that scene, or that, I'll call it the scene, or the opening photograph rotates, correct?
That is correct.
Do you agree with me?
It's changed periodically. I don't know if that's called rotating.
I'm fine with it. So I guess that's what I was trying to say with rotating. So you would agree with me that during the election period, this was the prominent welcoming photograph on your website, yes?
That is correct.
Okay. Okay. And again, one of the first posts on there is here's how to vote, correct?
Yes, I'm making a correction. I believe if you have opened to that page, but if you open to the about page, which most people would have opened to, that would not be the first page. But that certainly was it. Yes, the picture is on there, but it's not necessarily the opening page. But proceed. Okay. I'm sorry to interrupt.
No, please. Okay. And again, the integrity versus experience article we previously referenced, that's listed on there. The plain dealer endorses Rambo, that's listed on there. And then there's cast a vote that matters on there, correct?
I see that headline, yes. Uh-huh.
Okay. And again, these are all related to next one, letters to the editor, Grendel's dirty tricks. Solve this problem, vote Rambo. You see that one, correct?
Correct.
Would you agree that, and then there's a notice on there, how to pull your absentee ballot, correct?
Correct.
Okay. Would you agree with me that you were encouraging people to pull an absentee ballot and vote for Matt Rambo?
I would have to read the piece about the absentee ballot, but if I recollect it as how to pull an absentee ballot And if you want to vote for Matt Rambo, which ballot to pull?
I'm not asking what the article says. We've listed numerous, I just listed numerous articles.
Okay.
Here's how to vote and the culture. Appointed Supreme Court panel condemns Grandel. Integrity versus experience. Plain dealer endorses Rambo. Cast a vote that matters. Grandel's dirty tricks under letter of the editors. Solve this problem, vote Rambo. And then it's an absentee ballot application.
That is
based
correct.
on, these are all things that were on your website in the days leading up to the election.
Correct.
And a fair statement, your goal, because you wanted Judge Grandel removed because you believed that Matt Rambo would be a candidate who would appoint directors of the park to your liking, board members to your liking, that you wanted people to pull an absentee ballot or go in person and vote for Rambo and not vote for Judge Grandel.
We offered the people the instructions on how to pull an absentee ballot. It was a difficult procedure because the election was canceled on election day. We are also in favor of people having the right to vote. It would be up to people's own mind what ballot they chose and who they voted for. But we are correct to endorse Matt Rambo. You don't have to keep asking me that. We endorse Matt Rambo as we are permitted to do by our C4 status.
I understand that. But every post on this day relates to the election, and it relates to helping Matt Rambo defeat Judge Grandel. Yes?
If you were looking at the website on that day, you would have seen a lot more material on the website. You would have seen articles about conservation. You would have seen articles, photos, and events listed.
I didn't ask you what, I didn't ask. I'm not sure the procedure, if we were in a court of law.
Miss Partington, please listen very closely to the question and then answer only the question that's been posed by Mr. Crooks.
Okay, sorry.
Thank you. No, it's all right. No need to apologize.
Okay.
Go ahead, sir.
Thank you. Again, are you taking the position that despite the litany of articles all stacked together, not talking historically, I'm talking about all these related directly to voting for Rambo and negative information about Judge Grandel, how to pull an absentee ballot, how's that working for you? Another question about Judge Grandel, this one refers to Grandel lackeys. Cast a vote that matters is implying that the vote for Rambo matters. Are you actually taking the position before this board, or this commission, excuse me, that you were not advocating and not using your website to advocate for Matt Rambo and to advocate against Judge Grandel, and that all of these articles were driven to that idea?
I need you to restate the question, because I'm not sure if that was I'm not sure. Could you please restate the question?
Okay. Are you taking the position that despite the fact that the screenshot we're showing here in a form of a PDF has numerous articles either condemning Judge Grandel, promoting Matt Rambo, and encouraging people to pull a ballot and vote, that you were not advocating against Judge Grandel and for Matt Rambo?
Protect Geauga Parks was advocating for Matt Rambo.
And inherently against Judge Grandel. I mean, it's a two-person election, you're advocating for one and against the other, correct?
Correct. Yes.
Okay, thank you. All right. I've got, this is, I believe, sorry, I apologize. 6 was a duplicate of 5. Exhibit 7. And just for point of reference, this is the backdrop of the inviting photo. Now this is April 7th of 2021 is the date at the top of that, correct?
Correct.
And before this current election, or the most recent election period, I should say, you did not have political signs or endorsements of candidates or anything political at the top. They were historically nature scenes or scenes, pictures, photographs taken within the park, correct?
Correct.
So it was only for this election that you had Matt Rambo up top and we're endorsing him. So, okay. And this one is from January 20th, 2020. And it's, the author is identified as Protect Geauga Parks, correct?
Correct.
Okay. This would be, I will put to you that this was the press release or the commentary that was put on your website endorsing Matt Rambo. Do you recall seeing this?
Yes. Yes.
Okay. Who wrote this?
That was written by a group effort by the trustees of Protect Geauga Parks.
Okay, so this is the trustees' work themselves.
Correct.
Okay. Okay, and this is their actual endorsement there. Now, I want to draw your attention to a line at the bottom there, and this is your actual endorsement for Rambo, where it says, "We have been waiting for 6 years to unseat the current judge. This is our opportunity." And that was language that you guys all agreed on and wanted to put out there.
That is correct.
Okay. This is not the only effort to unseat the current judge, even though there wasn't an election cycle. Isn't that accurate?
Could you restate the question, please?
Hasn't Protect Geauga Parks advocated for the removal of Judge Grandel even when there was not an active election cycle?
No. Yes. I'm sorry. Yes, not during an election cycle. Correct.
Correct. You met with state legislatures about potentially removing him, correct?
That is correct.
You had a section on your website that specifically instructed people on how to file a judicial complaint against Judge Grandel.
That is correct.
And to be clear, that was a judicial complaint against Judge Grandel, not any other judge.
Actually, it was directions on how to file a judicial complaint that could apply to anybody.
Okay, so your position is that that had nothing to do with Judge Grandel. It was just about filing a judicial complaint.
No, that is not correct. That is not, you're misstating what I said.
Okay, I said specifically it was about filing a judicial complaint against Judge Grandel. You said, no, it could be filed against anybody. And I'm saying so to be clear, are you saying that the link to how to file a judicial complaint had no reference to Judge Grandel in it?
No, that is not correct. It does have reference to Judge Grandel, but it would be filing a judicial complaint against anybody.
Okay.
Okay.
Okay, I'm up to Exhibit 8. These are the instructions, and they're submitted by Dave Partington. He is I'm assuming he's related to you?
Yes, he is.
Okay. He's one of the other founders, correct?
That is correct.
Okay. Okay. And at the bottom of that page where you're encouraging people, telling people how to vote, you then attach to that page an endorsement of Matt Rambo.
That is correct.
Okay. Is it still your position that with giving instructions, you're not encouraging them to vote for Matt Rambo?
Those are two separate things. The absentee ballot tells people how to vote. It tells, and this statement says that Protect Geauga Parks is endorsing Matt Rambo, and that you would need to take a Republican Party ballot to vote for Matt Rambo.
Okay, so you're telling them
reading the article could choose for themselves.
You're telling them to take a Republican ballot. You're telling them to vote for Matt Rambo, and then you're telling them how, but you're not encouraging them to vote for Matt Rambo?
People who read this could choose for themselves. Protect Geauga Parks did encourage people to vote for Matt Rambo. That's no secret.
The purpose of putting this up was to allow people access so they could vote for Matt Rambo, correct?
I don't understand. What do you mean by access?
All right, you provided clear instructions on which ballot to pull, how to pull an absentee ballot, and what steps to take. And the same time that you were advocating for Matt Rambo. So the purpose of providing this information, given the endorsement, is you want people to vote for Matt Rambo, yes?
Yeah. Yes, that's correct.
Okay, Exhibit 9. Okay, we referenced this earlier, and but this was posted on your website, correct?
Apparently.
Sorry. Okay, Protect Geauga Parks. And the date of the article is from 2016, correct?
Correct.
There was no active election cycle going on in 2016, correct?
Correct.
You were publishing the fact that now admittedly, this is a reprint of a Chagrin Valley Times article, but you were posting it on your website and providing additional publicity to the fact that you were seeking, because to be clear, the group it talks about is Protect Geauga Parks, correct?
Correct.
And the purpose of this article is that you were seeking petitions, that you were circulating petitions to have him removed? Yes?
Yes.
You were also seeking meetings with several legislatures to attempt to have him removed, correct?
Yes.
Okay, would you agree with me that even though there wasn't an election going on, that was advocating against Judge Grandel?
It was advocating against Judge Grandel, but it was not part of a campaign.
I understand that. Is it your understanding of PACs that they only advocate during campaigns?
That they only advocate during, no, it's not, that is not my understanding.
Okay, would you agree that this
I'm not sure. Yes, excuse me. I would need to look at my notes on PACs before I answer that. I don't want to give the incorrect answer on that. I believe a PAC has to do with a campaign.
Okay. Would you agree that that collecting signatures for his removal and meeting with state legislatures is taking political action against Judge Grandel?
No, I do not.
Were you not lobbying state legislatures to remove him based on a state law?
Yes, we were lobbying and advocating for his removal by, but not by virtue of a campaign.
Okay, so
Lobbying and advocating.
So it's lobbying activity against Judge Grandel, not campaign activity. Got it.
Correct.
Okay. All right. Again, top Protect Geauga Parks.
Is this number 10? Is this complainants 10?
This is, my apologies, number 10. Complainants 10.
Thank you.
Okay. Would you agree with me? The date on there is March 4th, 2020.
Yes, I would.
Okay. Would you agree with me that this was before the election, even the actual scheduled election date, much less the actual date because of the complications with COVID?
This was during the campaign.
Okay. Could you please read the first line?
Geauga County needs to vote Matthew Rambo as its new probate juvenile judge on 3/17/2020. And I see that this is submitted by a resident of Geauga County.
Right, that you published on your website.
That was put on the website, correct? As all the other articles, yes.
Let me be clear. Can you identify a single article praising or endorsing or suggesting a vote for Judge Grandel that was available on your website from January 1st, 2020 till the end of April 2020 when the election was finally, when the absentee finally ended?
No.
Okay. So you would agree with me, the purpose of this is posting it on your website, again, is to encourage people to vote for Matt Rambo and vote against Judge Grandel, correct?
Yeah, correct.
Okay, and again, at the bottom is your endorsement, yes?
Correct.
And you agree the document speaks for itself?
Document speaks for itself. It was a letter to the editor, apparently.
Okay. Exhibit 11. All right. The date on there is March 6th.
Correct.
Okay. Grandel Judicial Complaint Scheme Backfires. That's the title, right?
Correct.
And this was about this. Do you remember this article or do you remember this issue?
I remember this issue.
Okay. So this is about an ethics complaint that was filed against Matt Rambo, correct?
Correct.
All right. And they lost that actual hearing, correct?
Correct.
Okay. Now, to be clear, other than the fact that Judge Grandel was running against Matt Rambo, there is no reference in any way, shape, or form to conservation, preservation, or the parks in this article, is there?
I have not read the article thoroughly, but I will.
Please.
I will
take your time.
There's probably no conservation in there.
Okay. And again, the document speaks for itself.
Excuse me, we will stipulate to the fact that Protect Geauga Parks endorsed Matt Rambo.
I'm not willing to accept that stipulation. The bottom line is the question is, what actions did they take? Just saying they endorsed Matt Rambo is not nearly the case here. So I will not, with all due respect, I won't accept that stipulation.
Okay. All right, thank you. Go ahead, Mr. Crooks, proceed.
Okay. Document 12, or complainants 12. Okay. Would you agree with me that this is dated July 30th, 2019?
Yes,
Okay. Would you agree with me? Okay, and just to be clear, this was before he declared for re-election, yes? There's
correct.
no, scrolling down so we can see that there is no endorsement or anything on there. Would you agree with me that there is nothing in this article that has to do with the parks?
I could not say. I would have to watch the video to see if there's anything to do with the parks on that.
Okay, that video was of the, you recall seeing that video before, correct?
I do not recall seeing that video.
You don't recall seeing the video that was posted on your website about a dispute with the auditor's office?
Yes, I probably saw it, but I probably saw it in July of 2019, and quite frankly, do not recall what was on the video.
Okay. But the article itself, there's no mention of the parks in there, and the video speaks for itself, correct?
I don't know. I don't know. You're asking me to speculate on something I'm really not familiar with.
Well, all I'm saying is that in the actual paragraph, the actual text of the document, there's nothing in that text that speaks to the park.
There is nothing that specifically speaks to the park in that actual document, in that actual text.
Okay. Complainants 13. Okay, starting with February 17th, 2020. That is the date on that, correct?
Correct.
And that is again it's a web page from Protect Geauga Parks, correct?
I'm sorry, could you repeat that? We just had a big wind.
Oh, I'm sorry. That's a web page from Protect Geauga Parks, yes?
It's on the website, yes.
Okay. All right. So this is a reprint of an article from Chagrin Valley Times, correct?
Correct.
All right. And the first line makes it clear that this is about the Geauga commissioners seeking to remove Judge Grandel from hearing an appeal on sewer assessments for 2 residents, correct?
Correct.
Okay. So here's my question to you. The park does not concern itself with sewer. The Protect Geauga Parks does not concern itself with sewer assessments, do they?
No.
Complainants.
Not in that case.
Complainants 14. Would you agree with me that April 1st, 2020, the election because of the extension for mail-in was still ongoing?
I'm sorry, could you please repeat that?
Okay, April 1st of 2020. Would you agree with me that because of the extension of mail-in / absentee balloting, because of the cancellation of in-person voting, that the election, the campaign, the race for the Republican nomination for Geauga County Probate and Juvenile Court was still ongoing as of April 1st? All the voting was not done.
Yes, that is correct.
Okay. All right. And do you recall this article?
Do you have a headline?
The headline is, how's that working for you now?
Okay.
Okay. And if I represent to you that the thrust of the article was that there was quite a bit of money spent on activity installations, which were unusable because of COVID, that it was another criticism of Judge Grandel's policies and procedures with regard to the park.
No, that is not correct.
It's not correct. Okay. It starts in 2015 after Judge Grandel replaced the elected director and referred to Grandel lackeys. Would you agree that it refers to Grandel lackeys?
Yes, the article does refer to Grandel Lackey's. I did not write the article, but I'm reading it right in front of me.
Okay, and I'll take your time. Please let me know when to scroll down.
Okay, you can scroll down.
Okay, thank you. Okay, let me know when you're done.
I'm sorry to take up everyone's time. I have never seen this article before.
No, take
But
your time, ma'am.
I am
Take your
aware of the
time.
playground it's referring to. Okay, I see it. I have read it.
Okay, all right. It talks about the use of public funds for the park district, doling out favors to narrow constituencies of political contributors, correct?
I am sorry, I did not see that in the article. I'm not sure we're reading the same thing.
It makes one wonder what could have been had the park administration follow the founding mission of the park district rather than use the parks to dole out favors to narrow constituencies and political contributors.
Okay, I see that now.
Okay, and right below that, it talks about you endorsing Matt Rambo and informing them that the ballots have to be mailed by April 27th because of the extended election, correct?
Correct, which is a separate from the article, which I believe that article was a letter to the editor. Now that I'm looking at that. Or a commentary, yeah. It's a commentary in the newspaper.
Okay, well, it's not cited to an author or anyone else. It says by Protect Geauga Parks, right?
That was not, I do not have knowledge of Protect Geauga Parks creating that article.
Okay.
But posting it, yes.
Okay. All right, we're now up to 15. Okay, and that is simply a publication that the Supreme Court dismisses Grendel's complaint, correct?
That's what the headline says, yes.
Yes. Well, it's okay. Again, that relates only to the election, not to anything related to the parks, correct?
I am not, I don't know what the text of that, it says see the full text of the decision. I do not know what that is reference, if that references the parks.
Okay.
I would have to read that article.
Okay. I'm going to ask you some questions about some exhibits that were submitted by your council.
I'm going to interject quickly. Exhibit 15, is there a particular date you want to identify on there? Because the only one is April 7th, obviously yesterday. And unlike all the other documents that had dates on them, that you referenced, there's no date that I see on there.
Understood. Let me pull that back up. There is no date on this other than the date that I obviously printed it out. And that's 2021, obviously. That being said, there is a 2020 and a March of 2020, 03/2020 in the actual link there. And I apologize for not having that link available, but it's listed as Protect Geauga Parks file, and if you went to that link, you would see the text of the decision. If I'm not mistaken, that actually references the Grandel judicial scheme backfires, and that has the same one on there. So I would put before the committee, the commission, that it's got a link, the same link that is on the 2020 March 6 Grandel judicial complaint scheme backfires article is the same link on Exhibit 15.
Okay.
Okay. Ms. Partington, do you recall giving an interview to Cleveland Schmooze?
Yes, I do.
Okay. Do you recall stating in that interview that one of the reasons it was founded was to combat Judge Grendel and to get a more appropriate, in your eyes, judge in charge of that park?
No, not in those words.
Okay. All right. I'm going to try something here with open tray. Hopefully this will play. Okay. And I'm going to bring this forward to 640. So I don't have to play the whole thing for everybody.
Are you going to mark this exhibit, Counselor?
One second. This
Yeah, which exhibit is this?
This is actually on the list I sent you. This is listed as, it's just a PDF with the link to the interview, but it's Exhibit 17.
All right, thank you.
Okay.
Can we have a date on whatever is happening here?
Hang on. I actually don't have that date. Ms. Partington, do you remember when you gave that interview with Cleveland Schmooze?
Yes, I do.
Okay, when was that?
It's a podcast. It was published. It was produced for appearance beginning October 5th, 2018.
Okay. Okay. So I've got it at 640, and I'm gonna play this, and then I'll ask you some questions. Okay.
Okay.
Okay. Let's see if this works. Okay. So would you agree that when you were interviewed for this podcast, you stated that the formation of Protect Geauga Parks was in response to the change in judge?
Can I just interject? This is Commissioner Norman. I didn't hear any of the interview.
Did that sound come through for anyone else or no?
Did
I didn't hear either.
I didn't hear
I didn't
anything.
hear it.
No, nothing came through here. So no.
Okay. Well, I will put to the commission that, and I apologize. Everything was going smoothly, and I tried playing this before through this, but it's the link is Exhibit 17. It is listable. I don't know what else I can do to get this to play because it's not downloadable. So I'm actually trying to play it through the actual website of Cleveland Schmooze, and apparently that's not playing. I'll just submit that Ms. Partington has stated she gave an interview, and the link is there, and she introduces herself, and just stay with that. So, okay. And back to all right, back to the PDFs and back to the last few questions I have for you, Ms. Partington. All right, so an exhibit, and I have to scroll through these because these are not separate. Okay, Exhibit 11. The Time for Integrity vote for Matt Rambo, 2/6/2020. You would agree that that was purchased and paid for by Protect Geauga Parks, correct?
Yeah.
Okay. Okay. Exhibit 12 that was provided by your council, you talk about the total, it says total expenditures, and then as a line item for total political expenditures from October 14 to December 2020, and then the cash balance of 1861.06, correct?
Correct.
Okay, so here's my question to you. And actually, I'm going to go down and ask a couple more questions and it'll make it easier to piece it together. Okay, so Exhibit 13 that was provided by your council are copies of the independent expenditures you filed with the Office of the Ohio Secretary of State, correct?
Not with the Ohio Secretary of State.
Filed, sorry, I apologize. That was, the forms are from the Ohio Secretary of State. They were filed with the local election committee, correct? Or election commission.
Independent expenditure reports were filed with the Geauga County Board of Elections.
Okay, local board of elections. Okay, so I see there, and this is for a time period. It's stated for, this is in relation to the March 17, 2020 election, correct?
Correct.
Okay, so you got an expense of $200? Yes?
Yes.
$3,010?
Correct.
$1,827?
Correct.
Okay. And then under the next form, we've got it $403. $460 after that. And again, these are all for advertisements endorsing, supporting Matt Rambo, correct?
Correct.
Okay. So the total spent per your form in 2020, I'm looking for the date on this form. As of 2/27, you'd spent $4,837, correct?
Correct.
Okay. So my question to you is this. You presented with, and I'll go back to it. There. Total expenditures, October 14 through December of 2020, you identify $102,665.06.
Correct.
Is that correct to the best of your recollection?
Yes, it is.
Okay. October 2014 until January of 2020, Geauga Parks was not in existence as a legal entity, correct?
Correct.
So can you tell me what portion of that 102,000 was expended before it became a legal entity, or was it all since it became a legal entity?
That was all since it became a legal entity, to the best of my knowledge. If there was any expenditures before January 2015, I am not aware of what those were.
Okay, so to the best of your knowledge, this is for fiscal years, entire fiscal years 15, 16, 17, 18, 19, and 20, totaling 6 total years, correct?
Correct.
Okay. Not going to ask you to do the math, but you're welcome to. I did, when you divide 102,000 by 6, you end up with about 17,000 average a year, correct?
I'm taking your word for that.
Okay, that's fair. All right. And if that is true, then $5,037, or actually $5,900, almost $6,000, is a little more than a third of about $17,000. Sound right?
You know what? You're asking me to do math. You'll have to ask our treasurer that question.
Okay, that's fair. But if the commission were to divide 102,000 by 665.06, like I'm about to do on my calendar, whatever the number is whatever the number is. And then 5,000, or the 5,900 that was spent in 2020, that taken against the average, that would be whatever that percentage is as well.
I'm sorry, I'm not following where you're getting the figures from.
Okay, you've said 102,665.06 is the total expenditures from, to the best of your knowledge, from January 1st of 2015 through December 31st of 2020, correct?
And I'm making myself a correction. I see that it says total expenditures beginning October of 2014. So I would say that we would have a financial statement that would probably have included a little bit of spending, very, very small, prior to being formed as the organization. But the
Okay.
102,665.06 is accurate total of our total expenditures since our inception.
Okay, so when you identified total political, well, let me ask you this. Who created this document?
I did.
You did, okay. So when you identify political expenditures, are you only referring to those that you disclosed on the Secretary of State forms that were turned over to the Geauga County Board of Elections?
I don't know what you mean by the Secretary of State forms, but I will say that the figures that total $5,900 in political expenditures are the only political expenditures Protect Geauga made in its entire inception, entire existence. And yes, that is on those, that would be on those two forms filed at the two different required reporting times as recommended by the Secretary of State's office to use that form.
Understood. And just so we're clear, when I'm saying the Office of the Secretary of State forms, I'm saying that, and I'm referring to Exhibit 13, and you can see right at the top left-hand corner is the logo and the production of it's a production of the Office of Secretary of State, which is, I apologize for any confusion, but that's what I mean when if I say office, the Secretary of State forms, that's what I'm referring to.
I forgive you for that.
Thank you, I appreciate it. Okay, so let's start with this. The entirety of that $5,900 was spent supporting Matt Rambo and trying to help defeat Judge Grendel in 2020, correct?
The entirety of that $5,900 was spent on political ads to endorse Matt Rambo.
For the purpose of defeating Judge Grendel. You can't have one without the other. Would you agree with me on that? Okay, thank you. All right, so here is my first question here. You're the one who defined political expenditures, correct?
Political expenditures are just defined in the code for C4s and defined on the Secretary of State website. We researched carefully what a political expenditure would be, and we followed that guidance.
No, I'm not questioning that you fully disclosed every dollar you spent during the election campaign. That's not the thrust of my question. So I apologize if that's the way it came off. My question is, with regard to political expenditures, one, based on your understanding, where does lobbying activity fall?
Lobbying activity is not a political activity or a political expenditure.
Okay, so it's your position that the money spent on lobbying legislatures, getting forms printed for the petitions, none of that is a political expense.
That is correct.
Okay. And it's also your position that none of that is political activity.
That is correct. Did not happen during the course of a campaign.
Okay. All right. Here's my next question. How many members are there to protect Geauga Parks?
There are 13 members that constitute the Board of Trustees. Our only members are our trustees.
Okay.
And as per our bylaws.
Okay, so you have 13 members and only 13 members. Okay, so you Protect Geauga Parks spent $5,900 in 2020 supporting Matt Rambo's attempt to unseat Judge Grendel. Yes?
Correct.
Where did that money come from?
All the money that Protect Geauga Parks comes from donations from supporters, which as well as the donations from the 13 members. But our supporters and anyone who chooses to may make donations.
Okay, that $5,900, was that drawn from a special election fund or was that drawn from just the general fund of Protect Geauga Parks?
It was the general fund of Protect Geauga Parks. We have one fund.
Okay. From January, well, let's go with this, from December of 2019 through the end of March of 2020, or the end of April of 2020, because that's when the election ended, was any solicitation made regarding the support of Matt Rambo? When you would solicit donations, was there any actions taken to attempt to raise funds that were given to Geauga Parks that were used to support Matt Rambo?
No, absolutely not.
Okay. So when people donated to protect Geauga Parks, were they aware that a portion of their funds was being used to support a political candidate?
That's a speculative question. People made donations independent of, we did not make a request for donations. We did not do a solicitation during that time in any way, shape, or form. People made donations based on their own decision to do that.
How did, and it's not, this is not provided, how did the donations of December of 19 through the end of April of 20 compare to other years?
I don't have that information in front of me.
Okay. And to be clear, there is no treasurer of Protect Geauga Parks, right?
Wrong, absolutely wrong. There is a treasurer. And all
Okay. And who is the treasurer?
the treasurer is Patricia Summer, who signed the independent expenditure forms.
Okay. And with regards to the donations that were taken, used for political, the donations were taken, part of which were used for political advertising. There's been no recordation of that, correct? No form submitted, anything else as far as to who gave what?
Correct.
Okay. If I may have just a minute, please. I think I'm done with my questions.
Okay, take your time.
Okay. I have two more. Did you host an event at which Mr. Rambo spoke during the election cycle?
Did I host an event?
Well, did Protect Geauga Parks host an event supporting Matt Rambo?
Parks hosted an event where Matt Rambo was introduced to the people there at the event.
Okay. Where did that event take place?
That took place at the West Geauga Library.
Okay. Was there a rental fee paid for that?
No.
Okay. Were there any? Okay. Were there any documents or any other literature prepared by Protect Geauga Parks in preparation from or in support of that event?
Yes, we would have put an ad in the papers promoting the event.
Okay. Is that ad in the paper included in the expense report that you filled out, that was filled out?
No.
Okay.
That was not a political ad.
Okay. The purpose of the event was to endorse Matt Rambo and to announce the endorsement of Matt Rambo and to introduce him to your membership, yes?
Absolutely not. Matt Rambo was introduced at the event as we would introduce any other person running for office that coming in. He, I believe, spoke for about 45 seconds and left the event.
Okay, so you advertised the introduction of Matt Rambo, who at the time was running against Judge Grandel, correct?
No, absolutely not. The event was a program by Dan Best, who was a naturalist at the Park District.
That's not what I asked you. Was the introduction of Matt Rambo part of the advertisement?
No, it was not. It was spontaneous.
It was, okay. Okay, those are all the questions I have, Ms. Partington.
Thank you.
Thank you, Mr. Crooks. Ms. Schutzauer, before I allow you to examine your client, I want to ask the commission's been going at it since for about 3 hours, over 3 hours with a 5-minute break. What's the pleasure of the commission? Do they want to take a break right now, or do we want to go ahead and conclude the examination of this witness and then take a break? Or do we just want to go ahead and continue?
This is Commissioner Cunningham. I'm fine with finishing up the examination of this witness before any additional break might be taken, but
Okay.
I defer to my fellow commissioners.
Same as I. Does anybody?
Commissioner Roma, I'm fine with rolling forward.
Okay. Anybody opposed to it?
No.
Okay, good. Well, all right, thank you. Then what we'll do, Mr. Utzauer, if you want to go ahead and examine your client at this point in time, you may do so.
Well, how would you like me to handle this? Because I obviously,
If you want to reserve and just call her as part of your case, that's fine as well.
yes, I'll just reserve and call her as part of my case.
Okay, that's fine. Any other questions? Then Mr. Crooks? I'm assuming not.
Not from Ms. Partington, no.
Okay. Any questions from the commission? All right. Thank you very much, Ms. Parkington. Mr. Crooks, you can call your next witness.
Actually, I am going to conclude my my witnesses. I would ask that the court consider all the exhibits that have been submitted, and we'll conclude my case with that.
All right. So you're offering into evidence then exhibits 1 through, what is it, 17?
1 through 17. And then I also made reference to, even though they are the other side's exhibits,
11, 12, and 13. Respondents exhibits 11, 12, and 13, correct?
That would be correct.
All right. All right, you're
Mr.
offering all. Yes.
Mr. Crook, for our benefit, can you stop screen sharing for us?
Oh, I'm terribly sorry.
Thank you.
Mr. Crooks, you indicated as you were going through just, as a relatively minor matter, that exhibit 5, not exhibit 5, exhibit 6 appeared to be a copy of exhibit 5. Are you also still wanting to enter exhibit 6 or exclude that?
Exclude that one. Thank you for,
Okay.
I had it in my notes, but it was not a big enough note for me to catch.
That's okay. I was tracking along and just wanted to make sure.
Mr. Utzauer, do you have any objection to the admission of those exhibits?
No, I don't.
All right, thank you. Then without objection, they'll be admitted into evidence. Assuming now,
Commissioner Kreitz,
yes.
this is Commissioner Cunningham. On the exhibit 17, we were unable to hear that. Is that being admitted into evidence?
That's a good, thank you very much. That's a good point.
Good point. I've missed that as well. I apologize.
One thing I may suggest, it's where to break at the testimony. Again, the link is, everyone has the link. And the time I played was from 6 minutes and 40, it starts at 6:40 and it ends at 7 minutes.
I would like to suggest if anybody listens to that they do not end at 7 minutes and they carry on for a few more minutes, because that will be in my questioning.
All right.
Okay, that's no objection to that. But the area that I was focused on was 6:40 to 7 minutes, and it related to the question that whether or not the Parks District, or she told them that the Parks District was formed, or Protect Geauga Parks, excuse me, was formed in response to a change in judge. And that's the reason, that was the sole reason I was presenting that.
Ms. Utzauer, do you intend, and of course it's your call, it's not ours. Do you intend to go ahead and introduce the PDF podcast?
I'm just going to ask Ms. Partington to testify to it since they were her words. So I'm not going to actually introduce it.
Okay. What would the commission like to do in that regard? Is there any way that we can go ahead and be able to listen to that?
I don't know. I know what I'm seeing on my screen, which is a very limited.
Yeah.
I'm trying to share that on my screen, and I'm not sure that it will come through either. But I've started it. Can anybody hear it out there?
I can't.
I cannot.
You cannot?
Yeah.
Cannot.
All right. I wasn't sure that I'd be able to do it any better, but I thought I'd try.
Commissioner Kreitz.
Yes.
Yeah.
This is Commissioner Cunningham. My suggestion would be that we hold off on the admission of Exhibit 17. I can, if I go to the exhibit set that the executive director sent us this morning, click the link and tee it up, I can hear it on my individual computer. Whether the commission wants to do that outside of publication online is I leave to the commission and the chair, but I think that individual members could, in a break, go to the link, get it on their own computers, and hear it during the time frame that the parties are advocating. Short of that, unless everybody.
Can you hear this?
Choose from breaking news, daily headlines.
I'm playing it on my phone. Can you hear it?
Yes.
Okay, let me, do you want me to play relevant parts?
Yeah, it's from 640 to 0700, right?
Okay.
About the people who make
Let's see.
He was from Shaker Heights. He moved, can feed a chickadee out of their hand. The Cleveland.
It's.
These sensitive areas, go ahead. And when we formed, it wasn't.
Okay.
He was then replaced by the current judge, and that's when the change occurred. So when there was a change in the board, the Geauga Park districts were formed in 1961 by the League of Women Voters, actually.
You need to go back.
Go back a little bit.
Can you tell us a little bit about that?
Yeah, we think that the park district has gone in the wrong direction since 2014. And let me follow up that a little bit by saying that park districts in the state of Ohio are controlled by that county's probate judge. Very unusual thing that most people don't know. So a probate judge appoints park commissioners.
We'll get to that point in a minute.
And they operate the park. Those park commissioners serve at the pleasure of that probate judge. Now, in most cases, the probate judge looks at this as a responsibility that he discharges and then lets the park commissioners do with it. You only have so much money. You either buy land or you build.
I'm trying to get to the point.
Playground, recreation, those kinds of things. So you can have a mix. But right now, the mix is all towards its recreation and none towards land purchasing of these sensitive areas. Go ahead.
And when we formed, it was in response to a change in the judge. The judge that had been in Geauga County for a number of years prior was Judge Chip Henry, who was killed in a bicycle accident. He was then replaced by the current judge, and that's when the change occurred. So when there was a change in the board, the Geauga Park districts were formed in 1961 by the League of Women Voters, actually, and have always been conservation minded with the mission to preserve, conserve, and protect the natural resources of Geauga County. And our mission is to protect that mission, which has now been changed. The Geauga County, for all the Cuyahoga County.
That's sufficient.
That's more than sufficient. That's more than I was going to introduce, but I'm totally fine with that.
Okay.
And now I guess would remove for the admission of that exhibit.
Any objection, Ms. Schutzauer?
No.
All right, then it'll be admitted without objection.
Thank you.
All right, thank you very much, Ms. Cunningham, for bringing that to our attention. All right, so you have no further witnesses at this time, Mr. Crooks?
That is correct.
All right, and just for purposes of planning, Ms. Schutzauer, how many witnesses do you have approximately? And we're not holding you to this. You'll have whatever time you need, but approximately how long do you think your case will take?
45 minutes.
Okay, all right.
I really don't know. I don't do much of this. I'm not sure, but I'll try to keep it brief. Can you take off the Cleveland Schmooze off? That's all I'm seeing on my screen.
Yeah.
Okay. If I may ask, I've got a client actually calling me from the federal penitentiary right now. Can I ask for a 5-minute break to address this because I don't have the ability to call him back and do a restroom break?